All right. Okay, I'm going to call this meeting of the Walton County Code Enforcement Board to order, and we'll stand for the pledge to the flag and the invocation. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Our heads, please. Heavenly Father, we thank you for this day and for this opportunity to, again, come together to serve each other and serve you. We pray that you would guide these proceedings and discussions, help us to honor you in all that we do. We pray, Lord, that you would be with this community and this nation as we continue to battle this pandemic, be with the families of the people that is affected, and please, Lord, we pray that it be your will that it quickly pass. Pray for the accident victims yesterday, for South Walton, and give their loved ones and family the comfort that they need. And Lord, please, as always, be with our first responders and our military men and women, and comfort them in the way that they need to, keep them out of harm's way to the extent possible. Pray these things, Lord, in your service. Amen.
Okay, has everybody had the opportunity to read the minutes and any additions or corrections? If not, I entertain a motion to accept them as written. And a second. All in favor?
Aye.
All right. Announcements, Mr. Lynch. Well, I'd like to say, Mr. Rose.
Actually, real quick for announcement purposes, for all of you board members that, since it's been a while, Georgina is our new administrative assistant, and she'll be handling any of your questions or results. So we'd like to welcome Georgina to the team. Also, as a reminder, since these are being sent out via Zoom, please make sure that when you are at the microphones or you are speaking into the microphones and give your name first so that the person on the other end can know who you are. Thank you.
And one other bit of business, if you have a cell phone, you might want to put it on airline mode or turn it off. I got to say that I'm a little upset at the change in the meeting time. In the past, we've always had a input into when the meetings were going to occur. And now they've been moved to, for those of us who still work some, a rather inconvenient time. And I don't know if there's any nefarious reason behind this or it's convenience, but it's not very convenient for me and some of the other board members I know.
May I, Tom, make a comment, please? I've been on this board for 25 plus years. This is the first time that we've ever had a slap in the face without being consulted about when we can meet. So I cannot do this. I cannot take a half a day of my time, even though it's on once a month. So I came out of respect for my fellow members, the staff. You guys do a great job. You're getting better every time. But I cannot do this. So I came to offer my resignation. And Tom, after all these years we've been together on this board, it's been delightful, but I can't do this. So if for some reason I end up changing, I'll be glad to come back and serve, but it's going to have to be at 5 o'clock or 6 o'clock in the afternoon so that I can be there. I can't do this. So I wish you all well and good luck. Thank you. Okay, I appreciate it. Thanks. Nice to you. Okay, take care.
Okay, everybody who's going to speak tonight, whoops. Oh, Victor is out of here.
I guess he meant that.
That leaves us with enough people? 4. Is there someone on the, who is on the? And does 4 constitute a quorum? Okay, then we'll proceed. Everybody who's planning to speak tonight needs to be sworn in. So if you're going to testify, please stand. Okay, then we'll proceed with the first case, case 19-008-665. Mr. Lynch.
Good afternoon, Board. Michael Lynch. Officer Michael Lynch, Walton County Code Enforcement. This first case is one of the old cases of Anna Reichert, who's no longer with us. And this is case 19-008665. This is a non-compliance and assessing fines hearing. The original violations were clearing permits, wetland restrictions on development, and stormwater clearing and grubbing. This is a property at Peachtree Circle in Santa Rosa Beach, parcel 302 South 20333100010010150. The property owner is HTA Group Investors, LLC. This property is located off of East Hewitt. If you turn north off of 98, go up East Hewitt, you come into a little area, and it's just off of East Hewitt, and it's Peachtree Circle. That little red box is the subject parcel. As you would have noted before in the previous hearing, with the clearing case, the picture to the upper left corner is the picture that Officer Reichert took at the beginning of her investigation, showing the clearing, and there's a like a water buoy there trying to keep some of the sediment from going farther. The picture to the lower right I took a couple weeks ago shows the same condition. As far as this case was presented at the May 21st, 2020 Code Enforcement Board, where the property was found in violation. The Code Enforcement Board required property to be brought into compliance in 30 days, which would be June 21st of this year, or a daily fine of $200 would be assessed until brought into compliance. On May 26th, the recorded final order was mailed to the property owner via certified mail. On July 7th of this year, an inspection showed that there was no change or progress or permits applied for. On July 9th of this year, Code Compliance Officer Reichert prepared and filed an Affidavit of Non-Compliance. A notice of hearing for non-compliance was sent multiple times due to the hearings being rescheduled for Hurricane Sally and a lack of a quorum. And then on October 2nd of this year, I prepared and mailed a notice of hearing non-compliance to the property owner. On October 5th, inspection showed no change in condition to the property and no applications for permits have been filed. On October 9th, a notice of hearing was posted on the property as well as at the South Walton Annex. I also prepared and filed an affidavit of service. On October 14th, I received the signed return receipt from the notice of hearing for non-compliance. And today, inspection shows no change in condition or permits. This is a copy of the final order that was rendered back in the May hearing. This is the affidavit of non-compliance that Officer Reichert had filed. And then this is the notice of hearing for non-compliance that I'd mailed earlier this month, and the return receipt over to the right. These are the postings on the property that I posted on October 9th, both at the property and the South Walton Annex, and the affidavit of service that I prepared and filed. This morning, this is the condition of that property, which shows the notice of hearing posted on the same tree, and there's been no change. What we'd ask is that you please find this property remains in violation. Please find that the proper notice of the hearing was given to the respondent. A fine accrued of $24,400 between June 21st of this year and today's date is being abated by the Code Enforcement Board due to the COVID local state of emergency. Once the state of emergency is lifted by the Board of County Commissioners, the fine will automatically be reinstated at $200 per day until the property is brought into compliance. At this time, I'd ask that you accept this presentation into the record. And if you have any questions, I'll try to answer them for you.
I'll accept Officer Lynch's presentation and testimony into evidence. Any questions?
So as of now, there's no fine?
The fines are accruing, but
Abated.
yes,
Abated, but it's an effective no fine. Okay.
right, as soon as that state of emergency is lifted, that's when the actual fines will, I guess,
Okay.
take place.
As a point of order, if in fact this were solved and that they become a repeat violator, then these fines, even though they were abated, they're on the record, right? That
Yes, sir. And that's
constitutes-
part of the purpose for us to get this on the record.
Okay,
My question.
okay.
Do we motion to?
Motion to
Motion at this, on these things, or would we already do it?
Correct. That as soon as the state of local emergency is lifted, that those fines will continue at $200 a day until it's resolved.
And they will not be abated.
Correct.
Right, right. The date the emergency ends.
Right. If the emergency had ended last week, then we would have accrued the fines
Right,
from last week to this date.
okay. So will somebody want to make the motion then?
I move we accept the officer's recommendations.
I'll second it.
Any discussion? All in favor? Whoop, wait.
I got just a question. I mean, all right, so we have, how is this impacted by this emergency, this kind of situation? I mean, what's the I mean, everybody's outside working. I mean, what's the impetus, I guess, behind the fine abatement while this emergency order is in place? I'm sure there is one. I don't know what it is. I'd just like to know.
My understanding or guess would be that because so many people are impacted, and I'm going to defer to Ms. Chrisman, but I think that the county is not wanting to further impose a financial crisis on somebody who may not have the means while this COVID issue is going on, but I'll let Heather
And on
direct
the other
that.
hand, it certainly gives somebody an easy out also. So,
Yes, it does.
And
yes, ma'am.
thank you, Heather Chrisman for Walton County Attorney's Office. The decision to abate the fines that have accrued during COVID was a decision, to our understanding, a decision of this board, and it was at staff's recommendation that we didn't feel that, given the circumstances, and they're ever evolving, but there was some time where folks were having difficulty finding contractors and people to be able to come out. And it seemed to the county that, in fairness, that we give them a little bit of latitude. And if this board chooses to begin assessing those fines and not to abate them, that is certainly a decision of the board. But just know that the county's perspective is that if you would wish to continue to abate those, that we are on board with that under the circumstances. But if you choose to do something else, you're the code enforcement board. It is ultimately your decision.
So it was us. Okay.
I
We're
believe.
the ones who decided.
I don't know that it was an
I don't
actual, I
think
don't
we-
know that it was a vote. I think there may have been some cases that came up, and that's the
Right.
decision that was made. And then carrying forward for the county, we've been presenting the cases with the understanding that your desire would be to abate those. If you choose not to, certainly that is your prerogative.
Okay, well, that being the case, then I guess I certainly wouldn't suggest we do so tonight, but we might want to consider
Well, it just got,
revising that maybe next meeting or.
yeah, it got presented to us as
Yeah, we
a
gotta have a
fiat
motion.
accompli, right? We were told, hey, they're going to abate the fines, and now
I thought
suddenly.
it was a county.
Yeah, I was going to
Time to
ask
go
who
forward.
made the decision, and you think we did?
Well, again, I believe that it was a few months ago when there was a few cases that came up, and that seemed to be the direction that we were, seeing that was the direction that county staff was looking to go, and our understanding was that the code enforcement board was feeling the same feeling towards it. Again, it's ultimately, it's your decision, but we are just in a position where we want to obtain compliance, we want to keep these cases moving forward, but we also want to be sensitive to unusual circumstances that we're all dealing with.
Sure, and I could, I certainly speculate that when we did it, assume that we did, it was a little bit different situation than it is now, too.
Yeah, but you know, if you look around, the new construction hadn't thrown down one iota.
That's what I'm saying.
Yeah.
There very well, and there certainly are going to be cases where the COVID state of emergency wouldn't impact, for instance, if it was somebody that had junk in their yard, you know, that wouldn't need a contractor to come out, that they could go
Right.
out and do it themselves. There's going to be cases that on a case-by-case basis, and we're certainly, you know, defer to your judgment as the code enforcement board to determine when it's appropriate and when it's not appropriate.
Oh, I just,
We reinstall it
Stand,
and then take each case separately and make,
exactly. Or yeah, just, let's think about it between now and next month as far as.
we'll come
possible.
back with a motion.
Well, there are quite a few of them here that we're gonna let go.
I understand, so, but, you know, presumably, we're gonna meet in November, so I think we maybe, but that's your decision, of course, if you wanna.
Well, I'm only one guy on the board, right? Yeah,
I mean,
yeah.
if you wanna bring
30
it up
more
for
days.
discussion now, is what I'm saying, I guess we could.
Well,
This was a case-by-case decision prior to,
Again, and I don't want to, this is from several meetings ago, and Mike may have a better recollection than I do, but there was a few cases, I think there may have been some circumstances where it did make sense, and again, it's up to y'all, and, you know, our feeling on it was that unless you feel strongly otherwise, at the county, we are willing, and we would like to continue these cases moving forward. We don't want to have them all backed up and nothing's happening, but, you know, we just want to be fair to the citizens, and there are circumstances that we recognize. In some cases, it may not be legitimate to blame it on COVID that they haven't cleaned up a piece of property. In other cases, there may be a reasonable explanation. So we're just aware of the totality of the circumstances, and, you know, certainly it's up to you, and we respect your decisions, and we'll abide by whatever it is that you decide.
Okay.
So I presume we have a motion and a second. I mean, if it's up to you as your decision as far as whether we want to discuss it anymore, I guess, is what I was saying.
Whether we're gonna vote it. Mr. Lynch, were you gonna say something?
Well, all I was going to add is that, as in all things, we just need to make sure that we're being fair and consistent from here on out. Maybe with giving a little bit more time and notice, some of the folks, if we start today, then what we need to look at is that going to impact the previous cases also? Because that's going to have a determining factor.
Right.
So we'll have to go back and look at all of those and determine where those fines are starting with. It starts today.
Well, my point, and I think it's fairly obvious, I mean, this could go on for however, who knows how long, and they've got a free pass indefinitely. I just think we need to draw it to a close at some point.
Yeah, it might be helpful in the future if the officer could make a recommendation that in this case, because of the COVID pandemic, we think that this person should get a abatement for now, or in this case, hey, the guy could pick up the trash in his yard. We recommend that there not be a fine abated. But if you could give us some guidance for the individual cases in the future, that would be helpful. And I agree with you. We can't arbitrarily today just say, okay, the deal's off the table, you guys suffer.
And I think maybe what we should do is look at the next meeting and say, to start off, that those cases will now be treated as we have before, that there's been ample time to get, you know, people's houses in order so that, you know, they can take care of their, but yes, today is a little abrupt, but I think that we can plan that for the next one.
Okay.
Let me ask the attorneys, are we allowed to have a separate meeting, or are we being conflict of sunshine law?
We could just have the conversation though before the next meeting. Yeah, no, I mean, when the meeting starts, put it on the agenda as a discussion of
That way
fine
it'll be a
abatement.
matter of public record, and we can move on from there.
All right, let's do that then. For the next meeting, let's schedule that discussion.
Yes, sir.
Okay, all right, then
Christmas
I'm going to
Day.
call the motion. All those in favor?
aye.
Okay, the motion carries. So we're ready for case 20-002-391. Officer Lynch again.
Yes, sir. Michael Lynch, Walton County Code Enforcement. This is another case from Officer Reichert. This is case 20-002-391 involving a clearing permit, development order approval, and recreational vehicles. This is located at 172 East Harborview Road in Santa Rosa Beach, parcel 242 South 214200000250040. The property owner is Angela Roberts. This property is located off of, if you go straight up Mac Bayou and make a right and go east on East Harborview, it's down probably about 6/10 of a mile or so. And the first picture in the upper left is a picture that Officer Reichert took that had the RVs in place, also shows evidence of clearing that had been done. The picture in the lower right is a picture that I took a couple weeks ago showing that the RVs have been removed, and I've since taken that violation off the code case. But there's a pile of what looks like outdoor furniture and some junk, which wasn't part of the original complaint, but that will need to be addressed. What remains is the fact that there are still no building permits or anything on file, they haven't been submitted yet, that would allow for the clearing. So I've just had a conversation a few minutes ago with the property owner, and she is going to be making those inroads to get that application. This case was presented at the June 18th Code Enforcement Board of this year, where the property was found in violation. The Code Enforcement Board required the property to be brought into compliance in 45 days, which was August 2nd, or a daily fine of $250 would be assessed until brought into compliance. On June 23rd of this year, the recorded final order was mailed to the property owner via certified mail. On August 4th of this year, Code Compliance Officer Reichert prepared and filed an affidavit of non-compliance. A notice of hearing for non-compliance was sent multiple times due to the hearings being rescheduled for Hurricane Sally and a lack of a quorum. On August 2nd of this year, I prepared and mailed a notice of hearing for non-compliance to the property owner. On October 7th of this year, inspection shows that the RVs, the campers, had been removed, but there are trailers now on the property and a pile of junk. No permits have been applied for at this point. On October 9th of this year, I posted the notice of hearing, notice of compliance on the property, as well as the South Walton Annex. I also prepared and filed an affidavit of service. On today's date, the inspection shows that there's been no change in condition. This is a copy of the final order that Officer Reichert had filed, as well as an affidavit of non-compliance. This is a copy of the notice of hearing for non-compliance that I had mailed earlier this month. This is the postings on the property. That's the wrong date. That should have been, I think, October. I posted it to the tree beside the gate, and then the posting at the South Walton Annex. This is the affidavit of service that I'd filed. And then finally, this morning, this is the property conditions. And again, the RVs have been removed. Those violations have been satisfied. There's still that pile of junk in the middle of the lot. So what really remains today is the property owner getting the building permit. That will satisfy the clearing and the development order. And so what we'd ask is that you find that the property remains in violation. Please find that proper notice of the hearing was given to the respondent. A fine accrued of $20,000 between August 3rd and October 21st of this year, and is being abated by the Code Enforcement Board due to the COVID local state of emergency. Once the state of emergency is lifted by the Board of County Commissioners, the fine will automatically be reinstated at $250 per day until the property is brought into compliance. At this time, I'd ask that you accept my testimony and presentation into the record. And if you have any questions.
I accept that into evidence, but note that date was incorrect. It should be 10/1, you said, instead of 7/1,
Yeah,
that page right there.
I need to change that. Yes, sir.
Any questions for Officer Lynch?
They have not even applied for the permit yet?
Not as of yet.
Then I'm ready to move.
And is Angela Roberts present?
Yes, sir.
Okay, it's your turn to address us then.
Hello, I'm Angela Roberts. The pile of junk is my furniture, lawn furniture. I put a tarp over it because it was the hurricane. I didn't know I couldn't leave outdoor furniture there. That's what it is. It's not a pile of junk. Very expensive outdoor furniture. That's not a pile of junk. I have an architect now. I went with him this morning. I've been through 2, trying to get this worked out so it would be beautiful. I've got it now. This is absolutely gorgeous. And he's gonna do what he's supposed to do. I'm new at this, but I'm learning. Okay. I have already got 4 permits on the other property that was a dock. I've built it. I've got it up. I'm doing the seawall. I got 4 permits. I didn't know I couldn't leave my furniture out there. I would have gotten a permit for it. I didn't really realize that. I'm really trying to work on this. I want this to be my dream. I'm making it as gorgeous as I can with the money I have, and I'm doing that. And I want it to be beautiful. I mean, I'm an interior designer. So, you know, I didn't know, truly, I would have moved that furniture if I'd known that was going to be a problem. We're going to get this done. I met with him this morning, and he's getting all the drawings ready. He just gave me these. These aren't for y'all yet, and I'll come to the planning department, and I'll do it. I want to do this right. I just promise you. I've been working very hard on all this. Over on the other property, it flooded, and then this flooded. So that's cleaned up from the flood, you know, because things were floating everywhere. So I put it all in the middle and put that blue tarp over it. So, like I say, that's good furniture. I can't just throw that furniture away.
When do you think you're going to submit to the county
As
first?
soon as, I mean, like I said, this morning, he drew this for me, and I want to do it. I'm ready. I just have to get my ducks in a row, you know? So I'm doing it as fast as I can. I'd love to build out there, but I can't build, of course, until I get y'all's permission. I wouldn't even think about doing that, but I didn't know I couldn't have the RV that was there. It was already there. I bought it, and the other one is mine that I brought. But I never dreamed. There's trailers all over that place. There's an Airstream on the other property. There's, I mean, everywhere around there. I never dreamed. I would have brought it, you know, if I'd known this was going to happen.
I'd suggest just get with Officer Lynch and
Yeah.
whoever
Yeah.
you
And
delegate.
like I say, I'm
And
a,
just do what you need to do to come into
Exactly.
compliance. Go ahead and get into the building department with your building permit application as soon as possible. Do you have a builder yet?
yes,
Okay.
yes. Trey
Yeah.
Youngblood,
Okay, well,
who
you'll need to
presented
get
this. I
him
have all the
involved and
guys.
Get on
Mhm.
in there as soon as possible. I predict we're probably going to rule like we did on the previous case. You've got another, at least until that next meeting, until we
When is
start
that?
imposing fines. And
When's the next meeting?
that's going to be November the 3rd,
Wednesday and
whatever it is.
yeah.
So by November 3rd, I have to move the furniture? Is
No,
that what
no,
you're
no.
saying?
You need to try to get a building permit, and you want to come back to us on that meeting and say that you've made a real step and you were
Yeah.
now
Oh, I
in the
have.
county.
They'll work with you.
Yeah. If-
Yeah, I'm learning. I mean, this is all a learning process for me. I mean, it's been a process.
Okay.
But I'm
you-
doing it.
You just need to keep going. and-
Oh, I'm going.
All
I'm
right.
tough.
Well, if
I'm
you-
here.
If you do the steps that you need to and you come tell us about it October the 19th, you'll be in good shape.
Perfect. Okay.
Right.
Thank you.
Yeah.
Thank you.
Okay, but we're still going to have to pass the motion. Right. So as,
Give her 30 days?
or,
I
yes,
Oh, did you move? Oh, then I move to accept.
the officer's recommendation, which is what, give her, how long did he give her?
In this case, it's.
Oh, no,
Yeah.
Yeah.
Continuation.
it's a continuation, right? So the,
Yes, it's just continuing, so if
Next meeting.
Ms. Roberts can get her building permit prior to the next meeting, and she can then come in and say, got it, it's a done
it all
deal.
goes away.
Almost table it.
Yeah. Well, do we tail it? No.
No, not the
We
meeting.
can just move it to the,
Alice.
we can hear it again in 30 days.
Right.
Okay, so then let's hear the motion.
I still move to, even though it's a
You accept,
continuance, huh?
Accept the,
Right. I just moved to accept findings and recommendations and that Officer Lynch presented in his testimony.
okay, what do you guys,
I'll second.
all right, in favor?
All right.
The motion passes. Okay, so we can move on to 19007745. Who's going to talk to us about this? Okay.
This is a non-compliance hearing. Good afternoon. For the record, Charles Cronin, Code Compliance Officer. I'm submitting my final report, proof of notification, and PowerPoint presentation as evidence. Slide 1, please. Code enforcement case 19-007745. Property owners Martinez, Ryan, and Victoria. Parcel number 33-1S-19-23-003-00C-0100. Violation is non-compliance. Slide 2, please. The the original notice of violation hearing was June 18th, 2020. Compliance would have been 7/18/2020. An inspection was done 7/20/2020, which shows no change. The most recent notice of hearing of non-compliance was mailed by certified mail September 22nd, 2020. The signature card, the green card, was returned signed 9/28/2020 by R. Martinez. And the photograph shows conditions in the front yard as of 7/20/2020. Slide 3, please. Slide 3 is a photograph shows conditions in the backyard on 7/20/2020. Slide 4, please. Those are the current conditions as of October 20th, yesterday, 2020. Slide 5, please. Recommendation, board issues an order of imposing fines, administrative lien. 2, fine of $250 per day until property is in compliance. And Chairman, will you accept the evidence as testimony?
I will accept it into evidence.
Questions?
looks like it cleaned up a little.
Yeah, it goes back and forth.
Did he move some stuff?
Yeah, I moved it to the backyard and then around to the side and then a little more to the front. And
Does it appear that he's working on the vehicles?
he's working on some of them and he's brought some others in. And he must be a master mechanic because he seems to be moving parts from one to the other. And one seems to be gone for a little while and then maybe he gets parts off from it and works on another.
You feel he's making an effort?
From what I understand, he's trying to get it ready and get it up for sale. And I think he's cleaning out the inside of the house, which makes more of a mess on the outside. But I believe he's making an effort, yes.
Is he here tonight?
Him or his wife, Victoria, neither one.
Back up a couple of slides, please, to that front, that one. What is that?
That is some type of tarp where he had one of the vehicles under there for a while and I
Probably
guess he was
painting it.
working on it.
First, I
just to-
thought it was some kind of tarp from hurricane damage, but
No,
that's not
no,
the case.
it's
Okay.
been there for 3 months at least.
So that's just a cover he's got out there that he's, all right.
When he pulls something.
So to come into compliance, he needs to just tell us one more time. what's the-
Remove all the inoperable vehicles, all the junk and debris from around the sides, behind the house. And also now there's overgrowth, which maybe eventually will die and wilt, but now it needs cut also.
There have been no fines accrued to this point.
Not to this point, it was after the recommendation.
All right.
The reason I hesitate, maybe this is extraneous to it, but it probably is. I read a book, made a mistake and read a book, okay? And the guy was making the argument that people like this, who are not exactly in the mainstream of the way of doing things, are a valuable asset to our community. And people who use their hands and try to make something out of less deserve to be encouraged and not necessarily to have to suffer for the property values and the aesthetics of their neighbors. And that's extraneous because the law is the law. You can't have a vehicle without a license plate. You can't have junk and debris. But it just can't help. When I read the book after this, I remembered this case and said to myself, he's talking about this guy. And, okay, enough said. I'll vote with you to condemn him. He's broken the law.
Neighbors still complaining?
Not that I've heard, and like we talked about in June, it's not unique to that neighborhood, these conditions.
Well, and I agree and certainly appreciate your sentiments there, but I mean, it's let's help him and redirect him to the right way to make that contribution. I mean.
Well, but the guy that wrote the book, his point was that, hey, why does the guy who wants the neat house with the mowed lawn get to impose his aesthetic over the guy who wants to be the innovator, inventor, mechanic type and, live a rather...
I think because they both bought into the same deal. I mean, it was whether they knew they did or not.
They did, yeah.
Who filed the original complaint, do we know? Another neighbor or somebody external?
I believe it was not the adjacent property to him, but I think it was somebody in that, within a block of him. If I can remember right, it's been 4 or 5 months. And they haven't complained since then, as far as I know.
Okay.
And he's a real articulate guy. I know you talked to him last time.
Yeah.
So when are you recommending the fine commence? Immediately or?
When the COVID epidemic...
That's my recommendation. I truly hope he sells the home and he wants to move all this stuff to his new home, which I hope is in Walton County.
Right.
But that's his, that's his ambitions.
Well,
So again, the fine, I mean, even if it's abated, which we presume we would do that until we discuss it next month. But the fine would start accruing immediately or from what point? Because to me, this is kind of like, even though we've heard it before, how long did we give him previously to come into compliance?
We found him in violation of June 18th, and we gave him till July 18th. So since July 18th, he's been in
So
violation.
why have no fines accrued like they did in the previous cases?
Because of the emergency, the state
No,
of
but,
emergency.
but they still accrued.
Oh,
Remember,
yes,
They
yes.
accrued, but we abated them. Are we
They've been
so
abated,
far
that's
abated?
correct.
So is that the same situation here?
Yes,
From July whatever till
today.
today?
right. And if we decide at the next
Okay,
meeting,
so
then
you
they will
just
pick
didn't
up.
state what the total amount was like?
He didn't give us
Right.
the 20 grand number.
Okay,
Yeah.
all right.
Yeah, it's close to that.
Yeah.
Thought he did.
No, if I haven't, I hereby do. Okay, so make the motion.
I move to accept the officer's findings and recommendations as presented.
And a second?
Second, whatever.
All in favor?
Aye.
Aye.
Okay, the motion passes. Then we're on to number 4. Tina Aufdenkamp, I can get this right, Aufdenkamp, 19002142. Ms. Aufdenkamp, you could sit right there and the officer will present his side of it, and then you're going to present your side of it.
Yeah, tell me.
Good afternoon, Lawrence Butler, Code Enforcement Officer, Walton County. I'll be presenting this case. This is actually a case for a reduction in fine. The case number is 19-002142. Tina Aufdenkamp. The property is 216 Griffin Cove, which is off of Indian Woman Road, South Walton. Next, please. I just did a summary up front. The case was heard by the Code Board in June 20th, 2019. The Code Board ruled the property was in violation. An order imposing fine was issued on September 20th, 2019 in the amount of $81. plus $1 a day for 365 days. The fine stopped accruing on March the 9th, 2020 due to COVID. So at that point, the fine was at $252. Director Matt Carpenter issued a determination which allowed her to keep one of the accessory structures, which was a small shed on the property. He signed that on July the 30th of 2020, and I filed an affidavit of compliance and recorded that on August the 4th of 2020. Next. This is a copy of the order imposing fine. The next one is, this is the director's determination signed by Matt Carpenter, allowing her to keep, like I said, one accessory structure as long as it was for her gardening stuff, I believe is what it was for. This is the affidavit of compliance that I filed. And this is a final inspection I did this morning, just a refresher. You can see it's just a small shed over there to the right.
That's the one that Mac Carpenter approved?
Yes, sir. There was originally two,
Right.
and she removed one, and then.
And that one's got permission to stay?
Yes, sir. And then my recommendations, I have no objection to reduction or waiver of this fine at all.
And the fine is $252?
That's what it accrued to, up to I call it a pause, when they pause the fines for COVID on March the 9th.
And she's in compliance now?
Yes, sir. And that's our goal. So I said I have no objection to reduction or waiving this fine.
Okay, I'll accept Officer Butler's presentation into evidence. And Ms. Aufdenkamp, do you want to say something to us? Could you mind coming up to this one, because we can't hear you? Or maybe that one will work.
Right.
That's better.
When I met with Matt Carpenter to sign, he said that he was going to make up a contract for me to sign saying that I would not run a business nor rent out that shed, and then I could keep it. When I met with him to sign that, he said that he would appear here on my behalf to request that the fines be waived.
I believe you. Okay. Want to hear a motion? Oh, I'll accept her testimony into evidence, and I shall close the public part of the hearing. And now we will discuss it or make a motion.
I move that we accept the officer's recommendation waiving the fine.
And Mr. Lovell, all in favor?
Aye.
Okay. Thank you. All right, one more and then we'll take a break maybe. We'll get halfway through. Two more. Okay, yes.
No, I ain't waiver.
Oh. Yeah, waiver, no money. Okay, then we're on to Reed Brandt, case 20003824.
Good afternoon, members of the board. My name is Carl Cross. I'm Code Enforcement Officer with Walton County Code Compliance. The case I'm going to be presenting is case number 20003824. And the property owner is Brant Reed. The parcel number is 11 2 South 2142 010 00I 0130. The initial inspection of the property revealed that it's an empty lot, and revealed that there were it's empty lot. It's down in the Driftwood Estates area. Shipwreck Once you go back into Driftwood Estates, you turn right off of Mac Bayou back into Driftwood Estates and follow Shipwreck back around, and it's right on the corner. The red box highlights it. This is a better overall view of kind of where you're at. Next. The code violations that I'm alleging for this property are development order approval, and then also for building permits. Next. On 7/21, back up, but on 7/4, I conducted initial inspection of the property. There were 2 watercraft trailers and a landscape trailer and a car parked on the property. The property had been cleared, what looked to me to be cleared of all minor vegetation, or mowed. Back on 2019, property appraiser aerial photos showed the lot was somewhat overgrown with undergrowth, but 2 foot, maybe 3 foot high shrubs and little palms. On June the 5th, I prepared and mailed the notice of violation to the property owner. On June the 12th, reinspection revealed the watercraft and a couple of the trailers were still being parked on the property. The notice of violation was then posted on the property. So I got my numbers switched around there. I made a typo. It should be 7/12 instead of 7/21. I think. No, I misstated that. On 7/12, I did post a notice of violation. Then I attempted to contact the property owner via telephone, left a voicemail. Periodic inspections between June the 25th and July the 9th revealed that the continued use of the property for storage of boat trailers along with parking of various cars. That time I had not received any communication from the property owner regarding his intentions. On July the 21st, the stop work order was issued. So we posted a stop work order at the direction of Director Matt Carpenter. On July the 22nd, I did speak with the property owner. He advised me he was waiting custom home plans to be delivered with the intentions of building his personal home on the property. I advised the property owner that all the storage on the lot would have to cease immediately or he could be subject to fines. Property owners also advised to contact the planning department to begin the necessary permitting process for the development order and building permits for the property. The property owner asked if he could go ahead and put a fence around the property. I also advised him he would have to speak with the planning department to make sure that that was allowable at this point. But I also advised him that the equipment that was stored on the property would not be allowed until proper permits and the land use was established. Property owner advised he spoke with planning on July the 29th and will be erecting a fence around the property. And again, I reiterated that regardless of the fence, nothing could be stored on the property until the property use had been established through the planning department. On August the 19th, the code board hearing for August the 18th, 2020 was canceled. And I noticed the owner that that hearing had been canceled by email and voicemail. On September the 1st, notice the hearing was prepared and mailed via certified registered mail. On September the 16th, I advised the property owner by email that code board had been canceled due to Hurricane Sally. September the 23rd, I notified the property owner via telephone and email that code board schedule for tonight had been canceled. On October the 2nd, you can go ahead, next slide. On October the 2nd, new notice of hearing was prepared and sent via certified registered mail. And then this is the conditions of the property on 6/4/2020. You can see where there was a driveway put in. There's a couple of trailers and a vehicle stored on the property, and it's been mowed pretty low. Next slide, please. And then today, the property conditions as of today. Again, I did my reinspection this morning. I observed a small black car drive onto the property. There was also a car and a truck already parked on the property. 3 trailers, one being a box trailer that appeared to be connected to the truck, a landscape style trailer, and a small utility trailer, along with a pontoon boat on a trailer parked on the property. These are photos of notices of violation that were sent. Next slide. The notice of hearing, mail, and certified mail receipt. Next slide. That was for the previous code board that was canceled. This is the most recent one for today's code board. Next slide. And the posting at the South Walton Annex. Next slide. My recommendations, please find that please find that lot 13, block I, parcel 11, 2 South, 214201000I 0130 is located within an unincorporated area of Walton County and subject to Chapter 7 of the Walton County Land Development Code. Please find that violations of the Walton County Land Development Code 1.1300, 1.1309C, and we can strike out the 5.0709. But those other 2 do exist on the property. Please find that proper notice of hearing was given to the respondent. The respondent is to correct the violation within 30 days of the date of this order, and that the respondent is further ordered to contact the Walton County Code Enforcement Department and arrange for a reinspection of the property once in compliance. That if the respondent fails to comply with the above actions or fails to bring the property in compliance with the applicable codes, that will assess a fine of $250 a day until the property is brought into compliance. And that fine, of course, after the discussion today, we wouldn't be looking to impose that fine until November, when you guys decide what you want to do. Ask that you accept my testimony into evidence and my presentation.
I'll accept Officer Cross's presentation and into evidence, with the exception of,
5.07.09.
right.
Which violation?
That was for storage, and I misquoted that violation. That was for storage. It actually applies to salvage.
Okay.
That's why it wasn't on the notice.
You guys have any questions for Officer Cross?
That's right. What was the stop work order for?
To stop any work going on the property. Bringing in any more materials or cutting of the, doing any more clearing or anything like that.
That's supposed to cover the
And it
storage
should
of the trailers.
have covered the storage of the trailers. That was also noted in there, yes.
Do we know when they started clearing the land, or?
I don't know when the initial cutting of the land was done. Mr. Reed is here, and he is wanting to speak on his behalf. I have spoken with him several times through all this process. I know that he has since, I think, made the decision. I'll let him speak for himself, but I believe he's relayed to me since made the decision that he does want to put a fence up, but he also has the property up for sale.
So as far as the clearing, was that, as best you can tell, that was all done at once? I mean, it wasn't like that.
Right, and I believe the majority of that clearing was done before he purchased the property. And then he went in and mowed it, there's still pine trees, it's still a treed lot. There's some lower vegetation that's still growing. The pictures from today, if you want to go back to slide, I think it's 9 or 8.
Do you have the right to mow the low vegetation? Or does that constitute illegal clearing?
Slide 9.
Yeah,
Cat, remember, not a bobcat,
bush hog, yeah.
only.
I don't
The
know.
road, yeah.
And I don't know what Mr. Brandt used to mow it with. He does operate his own business, and does some landscaping and stuff, so, but
I think it depends a little bit on the zoning, but
right.
I remember Max saying before that any clearing, without a permit was.
You can't go out there and.
Well,
cut
and
a path in.
that's where the building permit comes into play, because this is south of the bay.
Right.
So, there are no clearing permits for south of the bay.
right,
It would have to
right.
be in conjunction with a building permit.
Yeah, but surely you can hack away a path to get into your lot to see what you want to do.
Yeah.
Saying about
A reasonable access, yes,
Yeah,
reasonable access, yeah.
not the entire.
So what does he need to do to come into compliance? Get
So,
all the trailers
from-
and storage off of there?
From my standpoint, and I believe the county standpoint, if he moves all his materials off that lot, his trucks, trailers, all that stuff off that lot, lets the natural vegetation continue to grow, that he should be squared away.
okay. Then Mr. Brandt is here, right?
Yes,
Would you
He
like to?
doesn't have to restore any vegetation, he just needs to let it
well,
recover.
because the vegetation is growing. There's no reason to rip out vegetation to put new vegetation in.
Gotcha.
Mr.
Okay.
Brandt, you're going to come up here where he was, if you don't mind.
So I actually called about
Oh, yeah, tell us who you are, and you were sworn in, right?
Brant, yes, sir.
Okay.
Brant Reed.
Okay.
And I did call, I believe, some permit of Walton County. And what they stated was, as long as I did not disturb the soil, as in uprooting trees, that I was allowed to mow my property. They did not say a 10-foot allowance. They just said, as long as you did not disturb the soil, as in uprooting, bringing, digging down into, that would not be classified as land clearing.
Do you remember who that was or what department they were in?
It was the one permitting of, I guess, clearing, which would be building permit. I guess they transferred me multiple times because I called the wrong number, and they just transferred me and transferred me until it's the right department.
Okay.
And as far as the trailers go, it is zoned, the area, to do a home-based business. Now, it's my understanding I have to have a structure on that lot before it's classified as a home-based business. But I did call the HOA before I bought the property. I live in the area as it is on Loblolly, which is right behind it. And they told me that it's completely fair on HOA, that it's not in their area, and that it would be fine. I never thought to ask code enforcement if I could park my trailers on my property. They are in my name, not my company name, because I just became a company with the EIN recently. So all the equipment on the property is in my name and not a company name. And they said that would be classified as my property on my property. And as long as it's registered, running, no flat tires, everything has a trailer or a tag on it, that it is legal and not basically a junkyard of me just storing junk on a property. It honestly, it blows my mind that they say you cannot park your stuff on your property in a nice, orderly fashion. It's your property. I figured you could park your stuff on your property.
Okay. Do we have any questions from Mr. Brandt?
I mean, just intuitively, I would agree with him. I don't,
Yeah.
I like some clarification on that from
Me too.
planning or whomever, somebody in planning that, because, I mean, historically, and I've been around here 20-plus years, I see people mowing lots all the time, and I don't know why that's such a problem.
Officer Rose.
Director Carpenter is on Zoom and he has his hand raised to speak when you're done.
Oh,
Okay.
good. Let him talk
Good.
to us. Yeah. We get to see him somewhere?
Director Carpenter, you should be able to speak now.
Is use of the property without a primary development being approved there. It can't be used to store equipment. There's no house on this lot. It's a residential lot. We believe it's being used as a base for lawn service.
And if that weren't true, if he were truly just storing his vehicle there, is that legal?
I'll be doing it there. There is no primary use approved on that lot. There's no storage available without a primary use being approved there.
You have to get a building permit.
Got to get a building permit for a house.
All right, we've come up against that.
But that's true, Mac. You can't park a car on an unimproved lot that you own?
We're not talking about a car. We're talking about business equipment here. Trucks, trailers, employees. This isn't a single use of one car parked on somebody's lot.
Okay.
It's much more than that.
Okay. Do you disagree? Are you going to contend that, no, this is just your personal equipment that,
No, I never denied I use it for landscaping. I have a truck and a trailer that I use for landscaping.
that you park on that lot?
That I park on that lot. The boat is my watercraft. It's parked on the lot.
Yeah.
But the zoning of the area is you can run a home-based business. It's why I was under the intention that you can. I didn't know you had to have a structure in order for it to be the home-based business, and that's me not knowing what's what in this area. I tried to call and make sure everything was right. The HOA just never thought this far ahead of you have to have the structure built before you can park your stuff in your lot.
Well, home-based businesses, you've got to have the home as the primary use.
Yeah, you got to have the home.
I understand that now.
Yeah.
Yes.
Okay.
And I live on the road right behind it. It's just, it's taken me so long to get the plans that turn from 5 weeks to 6 months. Everyone wants to blame COVID for this and the price of lumber. And I have thought about selling a lot because I probably can't afford to, meet the code of you have to build this within the time period that I'm allowed. And I have no other place to store my equipment. If you call any storage facility around that holds big, long areas like RVs and trailers, they're all full from Sally and Michael and every other storm. They give you an excuse of why they're overcrowded and why they're building more storage units in the area. I have nowhere to put my stuff other than that lot, and that's why I either have to sell it and find something that already has a structure on it that I can park on, or I won't be able to afford to build right now. Is what I'm saying. The price of lumber's up 300%, and it's just not feasible right now for me.
All right. Any other questions for Mr. Brandt? If not, I'll close the public part of the hearing and we'll discuss it. I will accept your,
Now, am I allowed to build a fence of that area and classify that as,
you're asking the wrong guy.
but if I were to build a fence and leave my stuff there, as long as you wouldn't be able to see it, like,
Would need to go back through planning and get that approval, in the form of a permit or some kind of written approval. So that's not a question for this board.
that's the building permit department?
Correct. Or
Okay.
planning and building.
Yeah, Mr. Rose.
Director Carpenter has his hand up again. Go
Okay.
ahead, Mr. Carpenter.
I can go ahead and answer that. Building a fence to obscure the equipment will not be allowable on this lot. You got to have a single-family home. You can't just hide what we're doing there.
And if he did have a single-family home, could he then run the business from it?
He could potentially have a home-based business, can't have any employees, and can't park trucks there to make it look like a business is being operated from there. Home-based business in this particular zoning category cannot exceed 25% of the square footage of the single-family home, and everything related to the home-based business business has to be inside the house.
Okay, okay.
It is a residential neighborhood. I mean,
You're
Have
you're
they
living
been
in the
around
wrong
the
place,
neighborhood?
yeah.
You can't operate a long-term business.
right. I mean, that's understandable.
Okay,
How do people run businesses that, I mean, this is.
I can
practical.
point to
This
half,
is-
yeah, I get it, but again, we always say, look, you're entitled to file a complaint against somebody else, but when somebody files a complaint against you, we need to deal with that. And I know that it seems unfair, but hey, that's the way the system works. We're one case at a time, and your case is the one we're at.
Yes, sir.
All right, so I will close the public part of the hearing. What do you want to do? And that was to give him time, 30 days? Yes, sir. Okay,
To remove
to remove the equipment.
what was the amount of the fine?
250, is that right?
Again, it'll be
Sir,
waived.
the fine recommendation was $250 per day,
Yeah,
starting
when they,
after the 30 days, if he doesn't bring the property into compliance.
and if the COVID abatement isn't in force.
Right, so
So it would appear you're not in fine trouble, but it would appear that you're not going to win this one.
you
Can
need
we lower the fine?
to find somewhere else fairly soon.
Yeah, there
Right
is
now,
no
there isn't,
fine.
but
I
I
mean,
mean,
this
just
would
as
be,
a,
this would be a case where, when going back to my previous statement about, everybody gets a free pass on cover, this to me seems a little more valid
Yeah.
than maybe
Come
some
up
of the
with
others.
A
but-
motion.
Because I know what he's saying is true about workforce and
Places to go, yeah.
material costs and so forth are through the roof. But anyway, it's definitely a hardship, but you're just gonna have to find a way around it.
what's around this property? Are there
That's-
homes around this
yes,
property?
Yes.
On the
That's-
sides of it, in front of it?
Driftwood Estates is a residential.
Very
neighborhood.
developed. Yes.
It's primarily what it is.
Okay, then I'll listen to the motion.
Officer's testimony into record.
I'll second it.
All in favor?
Aye.
Aye.
All right, moving right along, since we got a lot to get through here. 20004412, property owner 210 Winston Lane LLC.
Okay, Code Enforcement Officer Michael Lynch with Walton County Code Enforcement. This case is also tied to Agenda Item 8. They got separated somehow, but this case is number 20004412, Parcel 363 South, 181610000001300, and it is property belonging to 210 Winston Lane LLC, located at 210 Winston Lane in Inlet Beach. Land use is neighborhood infill, and the violation here cited is 1.13.00. Before really getting into this, I'd like to also articulate that a lot of what's been going on recently with beach vending and a lot of the angst with the Board of County Commissioners and pushing us to try to come up with a resolve is based mostly on these two cases, Item 6 that is before us now and Item 8. This is not about beach vending. This is not about an approved activity that the county allows to happen on the beaches. This is about the use of the property as an amenity of another agency or organization. Next slide.
Let me just, if I may, before you go, so the two are how are they connected specifically? The
okay.
Case 6 and Case 8. I mean, are you
So-
going to address both of them?
Yes, sir.
Concurrently or-
Independently.
But concurrent, but I mean,
Yes.
same time. All right.
So this property is at the southernmost end of Winston Lane, off of 30A, and just to the north of it is the Point condominiums. Okay, so in summary, what was happening was the Point had contracted Rent Gear here to put beach setups on the property, and their clients at the Point were being directed at that time to go down Winston and access the beach through the public regional access there, and then they use that private property. And so that's why we're here. We're not issuing, or we're not talking about the renter or the vendor. Beach vending is an approved activity on the beach. This is just the correlation between 210 Winston and the Point condominium. And I think I'll make this a little bit more clear as we go.
I hope so, yeah.
Yeah. Next slide, please. Okay, the violation cited is 1.1300, developmental approval. Essentially, the activity that was taking place at 210 Winston, they were being used as an amenity, basically as a business, an extension of the Point, and that's the violation. If it were just people coming off the street and going down and renting chairs, there's no violation. But because the Point was directing their clients down there and using that.
Their clients? You mean
They're renters.
They're renters.
Okay.
They're renters, yes, sir. That made it necessary to have a development order in order to do that. So you're going to hear the same argument when we get to the Point.
Show us that map again. The slide, yeah, that. Okay, so the parcel in question is outlined in red,
Yes, sir.
and the Point is directly north of it?
The Point is up there where you can see the cursor moving back and forth. The Point is.
Oh, it's not contiguous to it, it's in the
No, sir.
neighborhood? Okay.
Right.
And because this property is on both sides of the road, right? It's on the north side of, what is that road that runs along the shore there? Where Winston Lane
Yes, the
terminates?
property is on the south side of Winston, so it abuts the beach. And that property owner has the right to allow people to use their beach, and that's not in question. The issue at hand is where there was an agreement made to allow the Point condominium, which is up there off
Right.
of 30A and 98, to allow their folks more or less to operate a beach club or an exclusivity, and that became the issue.
So then we're to presume that there was some kind of business arrangement between the property owner and the Point condominiums?
That's correct.
That would allow their residents to use, okay.
Are there written contracts in place?
It may have been verbal. I know that we've got at least one representative here that can maybe shed some light on that. But I'll try to, this is a very lengthy issue. We've been back and forth with this, so I'll try to make it as painless as possible.
Okay.
Kurt. On to the next one. Okay, so back on June 22nd of this year, I received a phone call from Director Carpenter, referenced the property at 210 Winston Lane and the Point Resort. Director Carpenter advised that a notice of violation and stop work order was needed to be issued to both properties as soon as possible in reference to the Point, using the 210 Winston Lane property as an amenity without it being part of their DO, their development order. On June 23rd, we good?
No, that made a lot of sense, yeah.
Okay.
Yeah.
I may not have articulated that.
No,
best,
you
so-
got us ready for
I
it.
was coming together.
Okay. So on June 23rd of this year, an inspection showed 18 setups, which your setup is basically 2 chairs and an umbrella. We're on the property. I posted a stop work order on the front of the door of the property advising that the use of the property as an amenity for the Point and all materials and equipment with the Point branding must be removed. I contacted Mr. Philip Poundstone, who owns Rent Gear Here, and advised the setups with the point branding would have to be removed. On June 24th, Mr. Poundstone called and advised that all the branding for the point had been removed and asked for a reinspection. I reinspected the property later that day and noted that the point branding had been removed. As Rent Gear Here has a valid beach vending permit for this property, the stop work order was lifted and the case was closed. At this point, when you've got literally the point setups and branding, that says what it is. The point folks are being directed to come down here and use this beach. When that branding was taken off, we can't tell who's using the beach, whether it's just somebody walking down the stairs and wanting to rent a chair. So we closed that case. However, on July 6th, Director Carpenter advised that the point continued to use the property over the holiday weekend, and this case was reopened. And we've got a photograph of a point employee carrying chairs for a client to the property with the point branding, which was provided by the point. On July 7th this year, I prepared and posted a notice of violation, notice of hearing, and a stop work order to the front door of the residence. And this was for the August 20th code board, which we ended up not having. On this date, there were approximately 30 setups on the property, but none were from the point. On July 8th, I prepared and sent a notice of violation and notice of hearing to the property owner via certified mail, and also filed an affidavit of service. On July 30th, I received a returned unsigned notice of violation, notice of hearing. On August 19th, the Code Enforcement Board hearing was canceled due to not having a quorum, and I made contact with the property owner and manager, Mr. Andrew Priest, by phone, and advised him that the hearing was rescheduled to September 17th. I also mailed a new notice of hearing to the property owner via certified mail. On September 2nd, inspection shows that there were bikes and beach setups being stored on the property. And it's one thing to have it down on the beach because beach vending is allowed. But when you actually start storing your materials on the property, again, we're right back to now that property, that residential area is now being used as a business. And we're back to where we started.
And there is a house on the property?
Yes, sir. Yeah. And the photographs will even make more clear what we're talking about. On September 3rd, inspection showed the equipment and bikes had been removed. And I will note that any time that I've needed something, I contact Mr. Poundstone, and he was very quick to respond. So when I identified this issue, the very next day I went back down and all those things had been removed. On September 17th, parties were contacted and advised that the Code Enforcement Board hearing was going to be rescheduled due to Hurricane Sally. And then September 30th, I prepared and sent a new notice of hearing for the October 21st Code Enforcement Board that was and notified the parties by phone. So back on June 23rd, this is what I had observed. And I know it's hard to see, but those dark blue chairs, there's a little banner on the back of the chair, and it says the point. That constitutes, an amenity. So that's where the violation occurred. Next. These were the postings on the property that same day for a stop work order. Us just basically asking, remove the items with the branding. Next. And so once it was all closed, we were fine until the 4th of July weekend, which we then had a point employee carrying their chairs or setups for a client. And if you look at the picture to the right, down in the lower portion, you can see where it says the point. And it may have just been a case where that particular employee didn't get the message, and maybe they thought that they were still sending the folks down there. But that got another complaint, and so we had to proceed again. This was also advertising from the point, indicating that they had private beach access, and it shows folks walking down Winston Lane. If you've never been down Winston Lane, it's a very narrow street. All that area through there, it's just very confined. So more foot traffic, bicycle traffic, everything. The folks living down there have to negotiate driving through pedestrians. Next. So this was the notice of violation and notice of hearing that was originally sent on July 7th. Next. And the notice of hearing postings. The affidavit of service. The new notice of hearing that was sent August 21st. And then on September 2nd, this is what I was referring to as far as the points, bicycles, and beach setups on the property. On the beach vending's fine, but on the property, again, constitutes a violation. Next. On the very next day, as I noted, Mr. Poundstone made sure that all those items were removed and were good again. Next. This was the notice of hearing for this Code Enforcement Board. And finally, please find that 210 Winston Lane, Inlet Beach, Florida, parcel 36, 3 South, 1816100001300 is located within the unincorporated area of Walton County and is subject to Chapter 7 of the Walton County Land Development Code. Please find that violations of the Walton County Land Development Code 1.13 did exist on the property. Please find that proper notice of the hearing was given to the respondent and that the respondent shall not allow any third party or business to use this property as amenity. There is no longer a violation on this property. All we are asking is that you find that the property had been in violation and that we want to stipulate that the property owners are to not allow any other agency or third party to use their property as an amenity. And with that, I would ask that you accept my testimony and presentation into the record.
I will accept your testimony and presentation into evidence.
So then are you, I guess
I'm just asking you to find that the property was in violation. There is no other fine or anything that we're asking.
So what are we to presume then that the follow-on to that would be if they do resume that same business activity, that it would be kind of an...
It would be a second offense, and then,
come back to the board for imposition of fines and penalties.
Right, and there could be enhanced fines as it would be a second offense.
Whether on that property or on another?
Just on this property.
Just on this one particular parcel?
That's because case 6 is particular to that property.
I get you.
Yes.
8 is to the board.
Yeah, I got it.
Yes, and Mr. Poundstone, I believe, is here. I don't know,
Yep.
and as far as 210 Winston, is Mr. Priest here, or is it, or you, Philip?
I'm going to speak on his behalf.
Okay, so that's my part.
Okay,
Mr. Poundstone, I think, has some more to discuss.
okay. You want to come up and present it? Introduce yourself, please.
Philip Poundstone, Poundstone. I am the owner of Rinkier here, as well as I'm representing you today, Andrew Priest, who is the owner of 210 Winston Lane. There's, as Mr. Lynch said, we could go on for 2 hours about this case. You guys are getting a 4-minute version of several months of a big story. I want to address a few things. The first being the bikes and the beach chairs left at the home overnight. That home is a rental home, just like there are thousands upon thousands of rental homes in the area, and the 4 bikes were placed there as rented, and we picked them up that next day. There's absolutely no violation that occurred there. The beach chairs were up at the house because 2 or 3 days before that, we had that tropical storm. Again, if we counted that as a violation, there would be hundreds and hundreds of violations in Walton County every time we had a storm event, that all vendors pull their equipment up to the closest area that they're allowed to by the owner, so it doesn't wash away in a storm. So just, this was not really brought up today, but I want to make it very clear on the record that many neighbors have that they have accused us of running a business out of that home. That home has never been used as a business, and that photo was essentially used to say that we were running a business out of the home, when in reality it was stored from a tropical storm and bikes were there because they were rented to the renter. So that covers that one. Mr. Lynch has been a pleasure to work with, and he's been very factual and very forthright. So I wanted to compliment him on that, and I feel very badly for the abuse that he has taken from the neighbors in regards to the complaints on this. I don't know if it's possible for you to pull up a map at the beginning of this presentation. But what I want you guys to understand is I know this is a formality.
Here's the map.
Thank you so much. Mr. Lynch stated that there are no violations currently there, and I take that very seriously, and there are not. The day we were notified about this, we had no clue this existed. We moved all the point guests to go to Orange Street, which is a public access, which is allowed. Very important that you guys understand, though, the whole point of this and why I'm standing before you today is because Mr. Lynch has been harassed by these neighbors every single day because they do not like tourism, they do not like tourists, and they do not like this Walton County beach access being congested. Everybody keep in mind that this is a public beach access that leads to a private piece of property. The county has a 33-foot easement there. So long story short, my argument had always been, and this
Talking
is
about the access between the point, the north-south.
on the west border of the property.
You're not talking about the Orange Street.
No, sir. I'm talking about the Winston Lane. So the neighbors essentially are accusing us of running a business and causing mass congestion, et cetera, when in reality, it is a Walton County public boardwalk that you take away vending. Let's say no vending was allowed at this parcel. There will be the same amount of bikes parked at the roadway. There will be the same amount of chairs and umbrellas on this property because people are going to go to the beach. That is what our TDC spends millions of dollars a year to do. I have a business that the owner allows me to set up beach chairs and umbrellas for people that want to be there, and I'm doing that legally. But understand, if this ultimately is about the neighbors' complaints, if we were to do something and remove vending, it does not solve the neighbors' complaints. But here's the irony of this. When you look at this map and you look 3 parcels over in those real skinny 3 to 4 parcels, okay, that is, if you look north of that, that is what we call Barbary Coast HOA. Barbary Coast HOA is 22 lots. You see them in the perfect rectangle there with the pool in the middle. Barbary Coast HOA is the absolute paramount of the complaints. Their HOA president is the one who is leading most of this charge that comes to all these meetings and complaints. What is extremely important to understand, Barbary Coast HOA does not own any Gulfront property. Barbary Coast HOA, on that 3rd skinny parcel to the east of 210 Winston Lane, they have an easement to use the beach. So when we talk about this being a violation of the point contracting with a home or allowing them to be an extended amenity for their renters and their guests and their owners to use the beach, I want you guys to understand that when you make a ruling per se on this, what we're essentially doing is pointing back to the complainant themselves and the hypocrisy that those 22 units have an easement to use the beach, which is right there, and they select a commercial vendor to set up their beach chairs. So if you go to the VRBO listings of those 22 units, it says private beach, 2 chairs and 1 umbrella included in your rental. If you want more chairs and umbrellas, call the beach vending company, Laid Back Beach Service, and they'll be glad to take care of you. Hear me very clearly, I support their right to do that. I think it is a wonderful amenity that they at Barbary Coast should have the ability to do so. But it is quite ironic that I've spent hours and hours of my time, and I stand before you today, getting the brunt of being made to look like someone that doesn't follow the rules when the complainant themselves are doing the exact same thing that I was doing that I'm going to be ruled today as it being in violation. So how that affects them down the road when somebody actually makes a complaint on them, I would hate for their neighborhood to lose access to go use the beach. So I just want you guys to understand that this is ultimately coming before you today is a much, much bigger issue, that what you do and say today, which really is beyond me, constitutes what's going to happen at hundreds of Walton County beach parcels. And I feel bad for Mr. Lynch because it's only here today because people have absolutely harassed him and have not given up until it's here.
Well,
So-
why don't you bring a complaint against those people?
Because I don't believe in that, with all due respect. I'm not knocking anybody that does complain. But I have asked this. I have asked this multiple times, and Mr. Stein, exactly what you said was said to me is, well, there needs to be a violation. I'm not going to be the person that makes a violation. I'm not going to do it.
I get
That's
what you, Okay.
That's not my style. So with that being said, I wanted to educate you guys in a very short time, as brief as possible. There are no violations today. We do not set up the point guests at this property because Mr. Carpenter and Code have asked us not to do that, and I respect those wishes. But at the same time, I want you to understand that because someone is screaming louder than I'm willing to scream, they're ultimately getting their way and trying to use you guys as a force to shut me down when they're doing the exact same thing. And please make it known for the record, I don't want them to be shut down. I want them to be able to do what they want to do. But in reality, they do not own 210 Winston Lane, and beach vending is allowed. So, any questions?
Yeah, please. Do
Yes,
you
sir.
have any relationship with the Point?
We do.
Actual relationship with the Point?
We did. We have a relationship with them to set up their bikes at their amenity, and also as well as the beach chairs.
So the beach chairs that you set up are for the Point?
We service multiple people. Okay, so let's focus whatever the date was on there, June 22nd or whatever the case may be.
Can other people besides the Point residents rent your chairs?
Yes, that was always the case. So when it was specifically brought to us that the Point can't do it, we said, okay, pull the plug on the Point. We then said, hey, anyone at the Point, we will still provide your beach chairs and umbrellas, but we have to go to Orange Street immediately at the Point. And when we get to that agenda item, they can discuss that too. But the Point got a shuttle, and they started moving all of their people to Orange Street.
And where's Orange Street on that map?
It's going to be probably a quarter mile to the east of that.
Oh, that's the public beach access with the bathroom and all that.
Or the blue roof bathroom, about a half a mile down the road. So as soon as we were notified, Mr. Snyder, we did not do that anymore. And so if you were, I don't know about today, it's quite slow, but if 2 weeks ago in fall break, if you were to go down to 210 Winston Lane, there would be beach chairs and umbrellas down there. They would not be for the Point guests. They would be for random people in the neighborhood that called my company and wanted to rent chairs there.
Could a Point guest, even though you couldn't use their branded equipment, could a Point guest make a private contract with you to rent a
If
chair?
they called my company and said, hey, I want beach chairs and I want it at that Winston Lane access, we would say, be glad to. But the contractual relationship with the Point, which is what they're referring to the violation is, we shut that down and we moved that to Orange Street.
So just to clarify that, you have no contractual relationship with the Point at this time?
At 210 Winston Lane, we do not. No, sir.
But you're contending that there is a contractual relationship between Barbary Point and the
Yes.
whatever the vendor, whoever the
Yes.
vendor is that services.
Laid Back Beach Service in Barbary Coast HOA.
Would Officer Lynch, would you have any knowledge of that, or who? No, who was that? That's your case.
It'd be Officer Lynch.
I don't have direct knowledge about the contract. I know that Director Carpenter had addressed that at a public meeting. And again, we haven't had a complaint for that property. If we do, then we will look at that the same that we've looked at 210 Winston.
Well, I don't understand why he's here, why we're all here today. If he's not, if there is no contractual agreement between the Point and you, Mr. Poundstone, then there isn't, and there's no violation. So.
Right, and in the code allows that even though by the time you come before the code board, that there may not be a violation at that time, the board can still find that a violation did exist. And that's all we're asking. So that on the record, that this would be a first offense for that.
I think he's just asking that we find that there was a violation in existence.
I get that.
A question.
Yeah,
but-
well, wait, let's ask him the questions and then we'll discuss it amongst ourselves, okay?
That's fine, yeah.
Okay? Well, look, we thank you for your testimony, and it is you will enter it into evidence, and let us discuss it among ourselves, and maybe we'll have another question for you, and maybe not, but.
Yes, sir.
Thank you for your articulate presentation.
I guess my question is, in other cases, if somebody was in violation, had a violation, and code enforcement went out to it, and they corrected the violation, we never see it.
Right.
Well, I guess I'm with you. I don't understand why we're seeing this one and not others
Right.
along this line.
Okay, the guy did something wrong, they told him about it, he corrected the violation, And now that we're supposed to go on record that there was a violation, so that if it happens again, we can call it a repeat violation. Is that right?
Heather Crispin for the Walton County Attorney's Office, and Mr. Stein just hit the nail on the head. We brought this case forward. Oftentimes, properties do come into compliance before the hearing comes before the board, and oftentimes those just get dropped from your agenda. In certain circumstances, we do ask for this board to make a finding. We're not asking for any fines in this case. If you find that there was a violation and the violation was corrected prior to today's hearing, we would not be asking for any fines. We are simply asking for a finding of fact, conclusion of law and order, finding that the property was in violation of the cited ordinance. The violation was corrected prior to hearing, so no fines will be imposed, but future offenses would be considered repeat offenses.
Do we have the right to find that and say future offenses will not be considered a repeat offense?
Well, under the Florida statute that we're operating under, if you do a finding that there was a violation, then we as the county could treat future offenses of the same nature as a repeat offense. And what that does is it makes it easier for code enforcement to be able to enforce. And so rather than normally we can't impose a fine until after it comes to the code enforcement board on a repeat offense, then once a officer witnesses a violation of the property, a fine can begin to accrue at that moment. Ultimately, it has to come back before you, but it just gives us a better tool to be able to enforce our codes. And in order to do that, we need to get a finding from this board.
But my point is, maybe I don't want to do that. Maybe I don't want you to be able to do that easily, because it doesn't seem to me that what he did warrants that treatment in the future. So do we have the right to say, yeah, finding of fact, he was in violation, but we will not consider the next one a repeat violation?
If we were to bring it back to the code enforcement board as a repeat violation, that would be a new hearing, and this board at that time would be able to determine how you wish to treat that case.
But isn't that unfair if we don't do that to everybody?
I don't know that we bring a whole lot of repeat violations to this
No,
board. and
I
ask
mean,
for the double
if
fine
somebody
amount.
is in violation and it comes before the board and we declare it's a violation, but we do no fine or any further, and then they repeat, it becomes a repeat violation. It seems to me that then all cases should be treated in the same manner.
Well, I think we've found repeat violations on a number of occasions.
But not ones where,
I mean, we're just, right now, I think, correct me if
Depending,
I'm
guys.
wrong, but in this largely a function of just the fact that we hadn't had a code board meeting for 3 months, and I mean, they were in violation, and they came into compliance before we could go through the due process to get them before us.
I think in this case, it's just a function of the county would like to be on the record that we feel that there was a violation. We understand the testimony and that you may feel that the violation was corrected, and we're just simply asking for a finding that there was a violation. That way, if it does occur in the future, if there is a new contractual agreement or something like that were to occur, that we'd be able to proceed as a repeat violation. Again, ultimately, it would come back to this board.
And we would still have the discretion as far as how to find it.
That
as
is
far as
correct.
repeat or not.
I believe Mr. Rose has Mr. Carpenter's words of wisdom for us. Is
That
that
is
right?
correct. Director Carpenter has a hand raised and wishes to speak.
Okay. If you'd put that microphone to the,
Director Carpenter, go ahead.
Thank you, members of the board and Mr. Chairman. Thanks for the opportunity to speak. Yes, this is a little bit unusual, but this is largely a precedent-setting case that we hope to use to help settle the dispute related to
you just went away.
Director Carpenter, we lost you.
vending. Okay, I'll get back.
You're back.
Try it again, because we lost it all.
Am I back yet?
You're back.
Okay. Essentially, this is a precedent-setting case that we hope to use to help us resolve the dispute related to beach vending and potentially beach overcrowding and where people can get to the beach. I mean, everybody does need to have some kind of beach access, and there's an appropriate way to get that through the development order process if you're a development that does not have a beachfront parcel. But we're trying to make a distinction between off-site amenities and beach vending, and it's important that we get a final order in this case that would support that distinction. Not because we're trying to punish someone, but because we're trying to establish a point of discussion, if you will, to move forward to help ideally make beach access and beach vending more compatible with one another, and in support of the number one industry in our county, which is tourism, largely because of the beautiful beaches we have in Walton County.
But it seems as if, in this case, you're punishing the wrong person. I understand your point, but why is it that these people have to suffer the consequence? They did nothing wrong.
Which people?
The point, okay? The point,
Talking about this case.
I'm not sure.
yeah,
The point did nothing wrong? Well, they absolutely did. They violated the land development code that requires you to get a development order for an off-site amenity. It's development without permits.
okay,
It may look like, and that's the distinction we're trying to make. You may recall that the Nature Walk Beach Club
yeah.
had to go through the development order process, and they were unsuccessful in getting their beach club for a number of the reasons that may have been brought up about this particular location. But we're trying to make a distinction between an off-site amenity and the development order process that needs to be followed, and beach vending, which is exempt from that process according to our present beach activities ordinance.
Okay, I understand. Yes,
Mr. Carpenter, the amenities issues you were just talking about, is that the second case of 4407?
With the point,
Yeah,
yes.
so
The point actually violated their development order, and 210 Winston Lane provided the location for that violation.
Okay, I just wanted to make sure the distinction and the board understands the violation, the alleged violations of the point of the second case 4407.
Now, had they gone through the development order process and gotten approval through that process to have an amenity on the 210 Winston Lane parcel, that would have been fine if it were allowed under the through the development order process, and it very well may not have been approvable in this circumstance. But that's neither here nor there. They didn't go through the process. The process is required to do what they did. And the owner of 210 Winston Lane participated in that land development code violation. And that's all we're asking for is your determination that, yes, the violation did exist, and it's been cured.
okay,
But that's what we're looking for, a final order that says the violation did exist. And it's been cured, and we're not asking for any fine or any kind of punishment at this point.
okay,
We just don't want it to reoccur without going through the proper process.
all right, thank you.
And I think this particular case can make a statement for our public in that regard because, as Mr. Poundstone suggested, this is not the only one of these. This is merely the first one that we've had a complaint on this year.
Got it. Okay, we
Thank
close.
you. Happy to answer any other questions you might have.
I have none. Anybody else?
No.
Okay. Well, we closed the public part of the hearing, and I suspect at this point we could take a vote or we could discuss it some more. I'm sold.
The motion.
Yeah. Dave?
I'll move we accept Officer Lynch's findings and recommendations.
Second.
All those in favor, aye?
Aye.
Okay, it carries. Can we skip to 8 at this point?
Let's do them both.
Well, it's hot and
Lord.
heavy, yeah.
Do we have to go through all of the same? Okay. Good.
Okay, Michael Lynch, Code Enforcement Officer for Walton County Code Enforcement. This is case 20004407, parcel 36, 3 South, 18, 16105 AAA, AAAA. This is the Point Condominium located at 10711 East County Highway 30A in Rosemary Beach. The land use is village mixed use, and the violations stipulated here are development order under 1.1300 and permit change under 1.13006. The property, this property is located right at the point appropriately named at the juncture of 30A and Highway 98. Just to the due southwest of that is the subject property at 210 Winston. So that gives you an idea of where these people were going. The same charge of 1.13 development approval as with the first case, and 1.1306, because they already had a development order and this was a change from that, they were doing something outside, then this is a post-development order, a post-permit change. Next slide. All of the situation that we talked about in the previous is identical to this. So what I would stipulate is the same testimony and documentation that I showed you before is going to pertain to this case as well. Kurt, just advance there a couple more times. The same photos, the same situations existed. Here, this is a shot that originally, when we got a complaint, this picture is back in May 27th, and it shows 40 setups. Beach vending, again, is a permittable activity. We weren't, and I don't know if at that time we even identified that it was the Point brand. The neighborhood was just up in arms about the volume of traffic. So next. That's then where we started looking at the complaint on June 23rd, and that's where we did identify that it was the Point. So all the things that we heard in the previous case are the same, and we're asking the very same thing that ultimately, Kurt, if you just take it to the end, ultimately that you just find that the same conditions existed for the Point as was with 210 Winston. I'd ask that you find that 10711 East County Highway 30A, Rosemary Beach, Florida, parcel 36, 3 South, 16105 AAA, AAAA, is located within the unincorporated area of Walton County and is subject to Chapter 7 of the Walton County Land Development Code. Please find that the violations of the Walton County Land Development Code 1.1300 and 1.1306 did exist on the property. Please find that proper notice of the hearing was given to the respondent and that the respondent shall not establish any amenity off-site of their property without an authorized development order approved by the Walton County Planning and Development. And so that you know that this, what we're asking is not really out in left field. If you look at any of the final orders that we proffer, midway down, there is a now there's a stipulation, and what it says is violations did exist on the subject property but have been removed. No fine in this matter shall be imposed. However, future offenses of the same nature as cited in this case will be considered repeat offenses and subject to fines as such. And I'll just.
Okay.
So that language was in there specifically for a case like this.
That's really not aimed.
So it's at our discretion whether we do it or not, yeah.
Board, at this time, I'd ask that you would accept my testimony and presentation and evidence. And if you have any questions, further questions, I'll try to answer those.
Mr. Lynch, are you asking the board to also include your testimony from the previous case of 4412 applied to this case as well?
I would indeed.
Okay, then I will accept both those testimonies and evidences, and presentation into evidence.
And I believe there are folks from the Point here that may want to offer
Okay.
their side on this.
This would be an appropriate time.
Now, Carlin Ilavar, I'm the general manager of The Point.
Spell your name, please.
Yes,
for the
it's Dannnielle, last name Carlin Ilavar, Carlin-Ilovar. So since this situation has taken place, we have implemented a shuttle, and we do shuttle all of our guests and/or owners down to the Orange Street access, as well as all of our associates have been trained not to advise guests to that Winston Lane access. Yep.
You advise them not to use the?
Correct, yes.
Why do you penalize, why can't they as individuals?
If they would like to set up their own chairs, yes, but we advise them that we would not supply them chairs down at that beach access.
Okay.
So they can still call.
They can
Yes.
still call.
Correct, they can call any beach vendor and have those established, but we would not provide them the Point Beach chairs to take down to that particular set access.
So the new location, you do supply the chairs?
Through Rent Gear Here, if the guest does rent those through Rent Gear Here.
And they
And then, of
have-
course, the management company is 360 Blue. We do offer 2 complimentary chairs and an umbrella for their guest stay, but those are set up at the Orange Street access.
At the public beach access?
Correct, yes, sir.
And do they have a brand that says The Point on them?
They do not.
Could they? Do you know? Or
I
is that a
would
silly
not have
question?
that answer.
Yeah.
I apologize. Since we're using Rent Gear Here, Philip, and maybe correct me if I'm wrong, with most of the chairs all say Rent Gear Here, because we advise the guests to see a Rent Gear Here associate.
Okay.
You know, I mean, this thing, it's just the business thing. It's the physical.
Yeah.
That's the issue.
Okay, do I have any questions? No? Then I'll accept your testimony into
Thank you.
evidence.
Thank you.
Okay, we'll close the public part of the hearing. And do we have any discussion? Do you guys? It's the same thing, right? We let it go. Well, I mean, it's the other side of the coin.
Somebody else move.
I'll make a motion that we accept the officer's recommendations.
Second?
All in favor?
Aye.
That carries. Okay, that's 8. We're going to take a little break, and then we're going to come back for 7, 9, 10, 11, and 12.
How long a break?
We're going to take, it's now exactly, well, on my watch, 4 o'clock. We will resume at 4:08 on my watch.
Gentlemen, just so that everyone is aware, Zoom will still be operational, so please.
Careful what you say.
Be careful what you say and watch what you do. Thank you.
It's not in the bathroom. Is it?
Yeah. Is the bathroom bugged?
Not really. What's likely happening is the Point kickback for them recommending
Get the officers
for the
next
chair,
month
which he
to,
can still do.
make sure they
but he
give
just
these,
can't.
make 2 copies
like
of
I
these
said
so I can be
before,
going over
that
them.
was
I
kind of
prefer the
it's kinda
summaries
like the
before so I
same
can
thing
go
with
over it,
Lane
but to at
houses,
least have
where
these
it's
up here
bleeding
so I
over
can be
into a
going through
business,
them.
that private owner of private property actually allowing a business on this
Hmm.
property.
Yeah, no, I'm not talking about before, I'm talking about here now, like, he gave me all of his, she's got all of hers.
What he said is this guy Andrew Priest. I'm
She's got a copy, I've got a copy. No, just here for right now.
probably doesn't matter.
Yes.
Doesn't matter, right? But
Because they need to come through me
it would make sense.
before it gets to her.
my partner is it what.
I know, but they haven't been given, and yeah, but they're not, but I like the way
And it's
Mike's
true,
doing it,
this
he's
past-
giving them to both of us, so.
Barbary Coast, if they're doing the same thing.
Complaining about him.
Yeah, I mean, I'd like to see that ferreted out somehow. In fact, I started asking, I make a complaint. I'll file a complaint right here.
I know what you're
Y'all
saying.
investigate.
You know, I see it all the time with what I do, right? I
Right.
see people clearing illegally. I see them putting down the wrong color fill.
Right.
I don't get the job because they get the job because they.
Yeah.
Somebody do it.
But I still don't want to call their
Undercut
law
you because they're
And
not
I'll
right.
be discussing that with him.
land south of the bay.
He's interfering with
Without
my
a building
representation, but
Without a
that
building
may be a moot point here soon anyway.
Then what happened is people started clearing
RVs.
some property or something and it get to be a mess. So they said, okay, now you gotta have a building permit. It's really a pain.
See, I'm
Yeah.
glad Mac was, I didn't know he was here, but I'm glad he chimed in because my question too, and I know Driftwood Estates pretty well. I mean, I did
Yeah.
a lot of that those are big lots. It is though, it's, what is it, conservation residential or something out there? There.
residential preservation or
But it's a residential neighborhood, and even though you can run a home-based business per county ordinance and the HOA, it's, there's limits to what you, I mean, like you said, like Max said, it's gotta be 25.
Discussing things that are coming before you.
No,
have
this
come-
is,
have come-
oh, we can't, just,
Does it make them before you again as the second violation?
okay. All right, I'll shut up then. I'll shut, I'm glad he clarified that.
Yeah.
I'm not the best at explaining things like that. My dad makes sense.
No, it came together well, but I figured it would. No,
It
you
was
did
great.
fine.
But I tell you, when you started out, it was like, huh?
Yeah, I was like,
Yeah,
and,
yeah. Oh, really?
yeah.
Well, somebody needs to call the, yeah.
The
Yeah.
walk over to nowhere.
Yeah.
And before we knew that the point was advertising that location and sending, the other big thing was all these steps. There's no on the number of steps, and the county has no interest in the usual steps to sit on this. The authority would say, sir,
Yeah,
are you
did you,
renting here,
right.
or where are you from? We can't do that.
Right.
There's no limit to the number of setups.
No, well, that's what we're looking at now.
Not on
All of
private.
this- All of this
Yeah.
is prompting us to look at spending and, like the occupancy on the.
Yeah.
So we're looking at whether we're going to look at the structure itself, or if it's an 8-bedroom monolith that can sleep,
Yes, 20 people, yeah.
Right,
and that's
right.
going to be maybe 20 setups.
Right.
And that's 40 chairs and 20 umbrellas. But we're going to look at how we can actually break it.
The best way to do it.
More to come. I'm
And
glad
it's
you're
probably
doing
not legally possible, is square footage.
I don't know. We're looking at that as well.
Yeah.
The problem with that is if they do it that way,
Yeah.
then you're gonna have these guys coming in and taking a 4-bedroom house.
No, I mean beach square footage. For every 1,000 square feet of beach, you can.
I didn't know. I mean, I've never seen.
If you just have some reasonable rule that everybody can follow,
Right.
that we really haven't, and I say we're never involved with, and that's why we
I
kick the
know.
can down the road,
I
because
know.
when they said, oh, look at all these setups, we said, hey, that's beach vending.
Right, that ain't
Call the
us.
TDC.
Yeah, yeah.
And so they kept on coming back and, it's like, well, you need to do something. No, that isn't a approved beach activity. And then it wasn't until really the point came in
Yeah.
that we saw, it's like, oh, okay, maybe we can do something.
Right.
How is this really
I gotta go.
the importance of a second offense?
Well,
I mean, it seemed like that was the emphasis. I understand what you're asking for. I thought it was, reasonable. But the second offense thing sort of,
well, there's under chapter 162 for a second offense, we don't have to allow if we can go up and say, right now, you're in violation, we're taking you to the code.
so it changes timeframes.
It can have to be.
Violation, immediately issue a notice of hearing and bring it to the next board. In fact, it even allows for us to call you all and say, we need an emergency meeting, have everybody come to an emergency meeting on the dates.
See,
Okay.
that's the whole thing with.
That's the
with a notice of
situation.
violation. This is public record saying they were in violation. They can't say, we didn't know. We've taken that away from them.
Okay.
That's the biggest part. It allows us to make a much quicker.
So it gives you more authority, basically.
It allows the
That.
process to move faster.
Yeah. Okay.
And in all honesty, there's a lot of politics in this.
Well, that's the whole thing. And, what I was thinking, this is more of the commissioners type thing than coming before a.
And just, if it hadn't been for the little girl carrying the chairs down 4th
screwed up.
Ladies and gentlemen, as a reminder, if you have not signed on the sign-in sheet, please do so. Thank you.
Wow. Okay. Word, man. What's the word?
Bird is the word. Early bird gets the worm. Early bird gets the worm.
I went down to UF. I'm just gonna cut the bullshit. He's good though. You want this guy. How are you? Good, man. He got little hands. That's what you look for. Little hands. You don't want big. I'm telling you. That's like they laugh when I had to get a urologist. I drove all the way to Pensacola.
You got it.
Right.
Well, when Mr. Lovell needs to return, we will.
Oh, Steve, Jimmy said he saw you out at Ten Lakes. Mark
Not a
told me he
bit.
saw you out at Ten Lakes.
They arbitrarily changed it.
Jimmy and Tommy. I used to have a lot out there. I sold it. I gotta go out there. Oh, he's gonna come down here tomorrow, I think. Yeah. We're fishing now. Tommy, you're both right there.
Yes. Yeah. If not, I'll come by tomorrow. But, yeah. Yeah.
Yeah. Here you go. That's just the stuff I brought for you. Prior complaint, no.
Yeah, this one. That really does call for some human input. You proved the case, right? Or you didn't prove the case?
I just wondered, this is the first step, now they'll take it to court.
I'm quite sure, oh, those people. I don't see why they would.
Well, it surprised me that the attorneys moved, whether.
Oh, themselves, yeah, they run a shuttle to the other place.
Shuttle now to a different location.
All right. Who, can we call this back to order? Okay. Places, everyone? All right, we're going to resume with case number 7. That's 20-00-3323, Philip Jones. Yes, sir. Mr. Cross.
Yes, sir, Mr. Chairman. My name is Carl Cross. I'm a code compliance officer with the Walton County Code Compliance. Case number 20-00-3323. Oh, was it off? I'm sorry. Should I start again?
No, well, oh.
For the record?
Yeah.
My name is Carl Cross. I'm a code compliance officer with the Walton County Code Compliance. This is case number 20-00-3323. Property owner's name is Philip A. Jones. Parcel is 363 South 18 16240000250. The violations that were alleged are 1.13.09C, building permits required, and number 2 is 2.02.11G, residential preservation special development standards, specifically as related to 8.03.10, the Inlet Beach Neighborhood Plan, paragraphs 2.2.3A and B. Okay. This property is located in a development called Pinewood Preserve. And it's located on the south end of that development on Sandpine Loop. You would take left on North Orange off of Highway 98 if you were going towards Bay County. And follow North Orange back in, and then you'd take a left off of North Orange on the Sandpine Loop, and it's just a circle. I think there's about a little over 30 homes in the development. The development order for this property specified a natural preservation area for all of the lots. So that's one of the things we're addressing. And again, the code violations, 1.1309C, building permits, and 2.02.11G, residential preservation. On May the 22nd, I conducted initial inspection and observed a screen room that was attached to the rear of the home and built into the natural vegetation preservation area. A review of the approved building plans for that home revealed the foundation and first floor plans did not include a screen room or a porch as observed in person during the inspection. On May the 28th, I conducted a visual inspection of the alleged violation on this parcel. There is a large screen room built off the back of the home and extends into the required preservation area. I met with the property owner at the home. He met me at the door. He alleged there were no violations on his property and stated there have been several code complaints made on several properties in the neighborhood over the past few years. The property owner advised that the former code enforcement manager, Williams, had closed the case from 2017 and noted that his property was not in violation. I attempted to provide the property owner with copies of the Land Development Code 2.02.11 and the Inland Beach Neighborhood Plan, page number 7. He refused to accept these documents and said we would let the lawyers work this out. I advised him that he would be receiving a mailing. On 5/28, I prepared and mailed the notice of violation. On 6/26, I conducted a follow-up inspection and noted that the violation still existed. And I had not had any further communication from the property owner. On between 7/21 and 8/28, I conducted numerous follow-up inspections and there were no changes to the property condition or communication from the property owner. On 9/1, I prepared and mailed a notice of hearing to the property owner. On 9/15, I received a phone call from Mr. Seth Galloway. He is the attorney for the property owner, and he requested the case be rescheduled for October code board due to him just being retained as the property owner's attorney. I removed this case from that code board agenda. which we didn't have, but, then on 9/30, our reinspection revealed there's still no change of the, condition of the property. On 10/2, notice of hearing was prepared and mailed. And yesterday, reinspection revealed the screen room is still in place and the violations still exist. Now we'll look at some pictures. On this property in particular, there is a vegetative preservation area that on all of the properties in this neighborhood. So, and it's different for each lot, actually how much they can go into, but in general, you can go about 3.5 feet from the back of your home and, you know, make a setting area or have a little deck or something, and that's all you're allowed to encroach into that preservation area. Anything beyond that, you're now in the preservation area, which needs to be natural vegetation, and this was all part of the original development order for this neighborhood. As you can see on 522, this screen room exists, and it's hard to tell from the pictures, but I measured the screen room to be approximately 7 feet from the back of the home, extend out approximately 7 feet from the back of the home. Additionally, after looking through our records with the building department and planning department, there were no permits ever associated with the screen room. It's south of the bay. It is a structure. It has to have permits. And it was not included in the original building permit for the home. Property conditions on 10/20 yesterday, the violations still exist. There's been nothing to do to remedy the violation. The approved building plans from 2/10/15, and if you look at those really closely, the preservation area in the back of this home is approximately 17 by 40, 680 square feet. And then also along the side of the house. And again, on these plans, there is no evidence of any porch or anything on the back of the home except for the small, really small entry porch that's on the, it would be on the north, no, it'd be on the southwest corner of the home. And if we go back to that picture right there, it'd be that screen room that you can see the long elongated window and that screen door. That's actually shows up on the plans. Next slide is the mailings from, I think these are original mailings for violations. Notice of violation sent and receipts. The notice of violation mailing, the actual mailing, and then the notice of hearing on 10/2, the letter posted at the South Walton Annex, and also the certified mail receipt. Now, what I ask as the recommendations is please find that 150 Sandpine Loop, Inlet Beach, Florida, parcel 363 South 1816240000250 is located within the unincorporated area of Walton County and is subject to Chapter 7 of the Walton County Land Development Code. Please find that the violations of the Walton County Land Development Code 1.1309C and 2.02.11G do exist on the property. Please find that proper notice of hearing was given to the respondent. Respondent is correct violation within 30 days of this date, of the date of this order, and that the respondent is further ordered to contact Walton County to arrange for a reinspection of the property. That if the respondent fails to comply with the above actions, or fails to bring the property in compliance with applicable codes and ordinance and regulations, according to this order, the board will assess a fine of $250 a day until the property is brought into compliance. Do you have any questions?
No?
Mr. Galloway is here to speak for the property owner.
Okay.
And there is also, Mr. Bacabello is here to speak on behalf of the homeowners association.
All right.
We have an association, if you guys would entertain him. I'd ask that you accept my presentation and testimony into evidence.
I do accept it into evidence. Okay, Mr. Galloway, would you step up here and talk to us?
Board Chairman, thank you. My name is Seth Galloway. I'm an attorney. I represent Mr. Philip Jones, who's the property owner. The parcel that we're here today on. I guess my client's reaction to his interaction with Mr. Cross was based on the fact that the identical complaint was lodged in 2017, and if I'll provide copies of it. In which W.S. Williams found that the case is closed with no violation. So almost 4 years later, we have another complaint that brings me here today.
Was the porch in existence then?
Yes, sir.
Can I accept that into evidence? And I will. Okay, we've got 2 copies. We'll send you one. You can have this one, Renee.
I believe Mr. Cross has a copy of it.
The county will stipulate to the existence of the previous case.
Okay,
So
that's the end of the argument.
That,
on
I
your
mean,
part.
that's why we're here. So I'll let the rest of them talk and then
Yeah, I'd sure
hopefully
like to
reserve
hear.
some time to hear from.
Okay.
I have a question.
Yes, sir.
You know, just glancing at this real quickly, what was the violation? Just that there was no permit? Or both, that it's in the preservation area without a permit? I mean,
I believe Mr. Cross, I'll let you speak to that. That's your.
The violations are both Land Development Code 1.13.09C, the lack of a building permit, and then also 2.0211G is the special, trying to.
Inlet Beach Neighborhood Plan.
Well, it refers back to the Inlet Beach Neighborhood Plan, but it's a residential preservation district is the actual land development code site.
Okay.
And then under the individual neighborhood development plans that were done for some of those developments down in that area, that is when you go back to the Inlet Beach Neighborhood
And
plan.
do we know when those plans were done?
Are you talking about the development plans?
The neighborhood, the preservation plan, all that was in existence and,
All that was in existence
2004.
before.
And I'll go ahead and disclose right now that I was the project manager for the developer of that, of Pinewood Estates at the time, in a previous life, so, previous career, so, I'm somewhat familiar with it, even though I don't remember a whole lot about it.
okay.
Right. So both are violations.
Okay. Mr. Carpenter,
Director Carpenter would
Yeah.
like to speak.
you're going to need to turn that microphone to the machine. Yeah.
Can you hear me now?
Yes, sir.
Go ahead, sir.
Thank you, Mr. Chairman. This particular location has preservation on the plat. And at the time of this violation, that was a violation of the comprehensive plan to construct something within the preservation area. and this is clearly without permits. And yes, there was a previous case, and it appears that Mr. Williams, the previous code manager, closed this case out without providing any evidence of compliance. And in fact, there was no evidence of compliance, and Mr. Williams is no longer employed by Walton County. So Mr. Williams closing out this case without any evidence of compliance is just wasn't a valid action taken by a previous employee, and he's no longer employed here as a result of that and other circumstances. But this is a clear violation. It's still a violation. It was before. It is still now a violation. And I'll be happy to answer any of the questions you might have.
At the time that the previous case existed, was there a hearing, or was it just arbitrarily, did it come before the board?
No, sir.
No, sir. It was never brought before the board.
It just went away.
Yeah, he's terminated.
Okay. Mr. Galloway, is it?
I was going to wait to the remainder of interested parties
Yeah, go ahead.
had their
Yeah.
time on this matter.
And then you could speak some more. Sir, would you come forward and introduce yourself, please?
Robert Boccabello. I'm the current president of the Pinewood Preserve Homeowners Association.
Okay.
Your last name for us?
Boccabello. I think it was probably mid-2017, I filed as a homeowner, not as a board member, filed the complaint against Mr. Jones and 4 others. This isn't the only violation, they just haven't gotten to him yet. As of December, will be the 3rd year that this has been going on. Mr. Jones was the president of the association. He was called in by Mr. Carpenter in mid-2018 with the other 2 board members. They were also guilty of similar violations. Mr. Carpenter did call me back to indicate that all 3 of them were in violation, but didn't indicate to me what the violation was. I wrote him a letter asking him what they were, and he never responded back. I pursued this, I have up until now, that's why I'm standing before you. Why Mr. Williams did what he did, I'm not sure. This is such a flagrant violation, especially of the preservation area. This is probably the most restricted preservation area in Inlet Beach, I would suspect. There's not anyone that can construct anything around any of those 33 homes past 36 inches. Anybody that's built a deck or anything else is in violation. None of these decks, not just Mr. Jones, but the other ones that'll come before these folks, are all flagrant violations. So for Mr. Williams to approve them, do your own speculation. It almost appears that he was paid off or something. I don't know what happened. And then it should have come before this board way before now, but I'm glad it has. I'm glad they've done their job, and I hope they continue to pursue the rest of the people that are also in violation.
Okay, questions from Mr. Boccabello? Hearing none, I'll accept his testimony into evidence. And is anyone else going to speak on the matter? Yes, sir.
Mr. Chair, Mike Lynch, Code Enforcement. Just to let you know that this is the first of many. We've identified several properties within this community, and for time and case management purposes, we're not addressing all of them at once. We're taking the most egregious cases first, and we will be pursuing other cases. So we are looking at all the preserves, and I'd met with Mr. Boccabello and a couple other members of the board previous to this, and had gone through the neighborhood myself and identified areas. So this is the culmination. This is actually our first case that we're presenting in this neighborhood, and there will be more.
Yeah, Mr. Cross.
Just to add to Mr. Lynch's last few statements there is, I do have 2 more additional cases that are open now in this neighborhood. And one of those cases is also a board member.
Okay. Mr. Galloway, I'd like to hear from you.
Well, it seems a little inequitable for a homeowner to have his property investigated, have a no violation, and then 4 years later, presumably be subject to fines and/or removal of a structure that has been in existence in reliance upon the county. Whether Mr. Williams did his job right or not, he was the county hired him, he showed up, found no violation. My client doesn't believe he should be forced to remove that, his structure, or be subject to fines because of be it malfeasance, I believe there was a reference to, or malpractice of the manager at the time. That's it.
Okay. And we'll close the public part of the hearing. Okay, I'd like to hear from you.
Open and shut. Guilty. Illegal construction, illegal porch, built-in setbacks. There's no excuse for this. It's got to stop.
Double jeopardy?
No, not at all. The employee's been terminated. The law still was violated. Setbacks were violated. The preservation was violated.
Right.
It's a clear case.
Now, I mean, I could see if he relied upon whoever it was, Williams, to actually build it, but the fact that it was already in place.
No permit.
Without a permit.
If he'd have had a survey.
There was malfeasance, mistake, whatever is
Right.
still a violation.
We all know you got to have a survey to put a deck
So he's
in.
gotten away with it for 4 years.
Not too bad.
That's
Guilty. I vote. No, we got to stop it.
It appears to me there was no permit
None.
issued. And
Right.
if he would have gone through the permit process,
He wouldn't have gone.
they wouldn't have passed the permit. So it
Correct.
feels like the reasoning or anything is on the homeowner by not applying for the proper permit, not the idea that, this other gentleman didn't see a violation.
Violation's
Right.
clear.
When you
Members of the
point
board, could you open this back up to the public just briefly for one more comment, inquiry that I believe needs to be on the record?
Okay.
Does the board or the county intend to go back and reevaluate Mr. Williams' decisions during his tenure?
I certainly don't. That's not my prerogative.
Sure.
Yeah. Okay, well then, seems pretty clear. Somebody want to make the motion?
I move we accept the officer's recommendation as stated.
And that was, what's he got, 30 days or $250 a day? Abated until the end of the COVID.
Yeah, still got COVID.
Second?
Second.
Dave? Oh, we'll call the question. All in favor, aye?
Aye.
Aye.
All right, it passes. Okay, let's move on to number 9. Case number 19-002552. Look at the house.
I was wondering if that thing ever.
I don't think so. I mean, there's a name on it.
Good afternoon, Board. Lawrence Butler, Code Enforcement Officer, Walton County again.
Thank you.
This is case number 19-002522. The parcel number is 232 South 2031700000201. Joseph H. Marshall, care of James Marshall. The property address is 204 Indian Woman Road, Santa Rosa Beach. The land use is conservation residential. The violations are 7.02.01A1, junk and litter prohibited conditions, and 7.02.02A, overgrowth prohibited conditions. A quick summary up front. Complaint was received for junk, debris, overgrowth, and non-operating vehicles on the property. Inspection confirmed the conditions reported in the complaint. Notified the property owner. Some progress was made cleaning up the property, but as of today, the property remains in violation. The location, like I said, is off of Indian Woman Road. You turn north on the Indian Woman Road off of Chat Holly, and it's a couple of blocks up there on the right, the small parcel in that big, I think it's like a 10-acre parcel. Code violations. Junk and litter prohibited conditions. No owner or occupants shall cause or permit junk, litter, or junked or abandoned motor vehicles to remain in or upon any yard, garden, lawn, open outbuilding, or open area of any private property in Walton County for a period in excess of 30 days. The second violation is overgrowth. Excessive accumulation of weeds, grasses, and shrubbery upon any lot or parcel of land within the unincorporated areas of Walton County, which exceeds 18 inches in height, to the extent that such portion of the lot or parcel of land is or may reasonably become infested or inhabited by rats or other vermin, or may furnish a breeding place for mosquitoes, or reasonably cause disease or create a fire hazard, is declared to be a public nuisance and is hereby prohibited. For the complaint and the investigation, the initial complaint was received on April the 15th, 2019 for junk and debris, non-operating vehicles, and overgrowth. Site inspection revealed multiple non-operating vehicles, one boat, and an overgrown yard. Sent a regular mail letter to the property owner. July 31st, reinspection confirmed that 2 vehicles have been removed from the front yard. And I've got a lot of pictures to show the progress over the time. I sent a notice of violation to the property owner via certified mail. September 19th, reinspection revealed overgrown grass had been mowed. Multiple non-operating vehicles remain on the property. January 30th, 2020, received a voicemail from James Marshall. He stated his father, Joseph Marshall, had passed away the previous year. He had requested AAA or AA auto salvage, to remove the non-operating vehicles and was requesting a 30-day extension. I returned his call on January 31st and gave him a 2-week verbal extension to complete the cleanup. March 21st, reinspection revealed no change since last inspection. Same on May the 5th. September the 1st, I prepared a notice of violation for September code board and sent to the property owner. Of course, the September code board was canceled. September the 2nd, reinspection showed the grass had grown up again. September the 16th, I called Mr. Marshall, let him know that this board had been rescheduled to the 23rd. Then that was canceled. Prepared a mail notice of October board. October the 2nd, I received the delivery confirmation. I called Mr. Marshall and let the voicemail state the code board was today at 2 o'clock. And into our inspection. This is the initial inspection on April 18th of 2019. Here you can see the house, there's a mobile home, and the grass has grown pretty high around it. If you look into, it's hard to see in this picture, but there's looks like a red Ford step-side truck there. To the left, there's also looks like a cab of another truck. If you go back to a couple of slides more. Okay, if you see in this picture, you can see 2 cars in the front yard there. Okay, so go forward 2 slides, 3 slides. Right there. Okay, now you can see those 2 cars have been gone. They're gone now. So that there was some progress being made. Next slide, you can see the grass has been mowed. That was September 19th. Same for the next slide, just another angle. Next slide, May 24th. You can see the red pickup truck is gone from the driveway. Same on May the 5th. September the 2nd, there's a different red pickup truck there now. Looks like a GM model with extended extra cab, but not a step side like the other one. Next slide, you can see the yard is overgrown again. And next slide, please. This is the regular mail letter I sent at first. The next slide is the notice of violation. The next slide is the delivery or confirmation for the notice of violation. It actually returned and said that there was a new address, so I sent the letter to them as well. Then the next was a notice of hearing. I only included the one for today's hearing because it's been ongoing. There's the delivery confirmation. Of course, Mr. Marshall's here, so obviously you got that. And today is conditions of the property. The grass is overgrown. The red GM truck is still there in the back. And it's hard to see from these pictures, but that cab of that one truck is still there, and there's a couple of vehicles back in the back of the property. Next slide, please. Okay, recommendations. Please find that 204 Indian Woman Road, Santa Rosa Beach, Florida, is located within the unincorporated area of Walton County, is subject to Chapter 7 of the Walton County Land Development Code. Please find the violations of 7.02.01A1 and Section 7.02.02A of the Walton County Land Development Code do exist on the property. Find that proper notice of the hearing was given to the respondent. The respondent is to correct the violation within 30 days of the date of this order, and that the respondent is further ordered to contact Walton County Code Enforcement Department to arrange for reinspection of the subject property to verify compliance with this order. That if the respondent fails to comply with above actions or fails to bring the property into compliance with applicable codes, ordinances, and regulations according to this order, the board assess a fine of $150 a day per violation until the property is brought into compliance. I would ask that you accept my testimony and presentation as evidence.
I will
and I would
accept
be
it.
open to answer any questions.
That's 150 a day?
Yes, sir.
I will accept it into evidence. Questions? No questions for Officer Butler? Yes.
He's gonna. Establish the current ownership of the property.
Oh, who owns the property?
It's still listed as under Joseph H. Marshall, and his son, James Marshall, is here.
It's in his estate.
Right.
And when the estate gets processed, my sisters get it.
Who is a personal representative?
Do
What does that
do we need to let him speak?
Oh, well, do you know who the personal representative is of the estate? Did you notify the personal representative?
I notified the person that was on the property appraiser's website is where I sent the mail to, and I've been corresponding with Mr. Marshall, who's here today.
To establish ownership.
Oh, right.
Who represents the estate, if they were notified properly too?
And that would be the executor of the estate?
Representative, yes.
We don't know who that is? Do you know Mr.
Maybe
Marshall?
Mr. Marshall may.
Sir?
Do you know who the executor for the estate is?
My sister, Julie Nelson.
She's the one that he put in charge while this goes through the,
Yeah, I reckon that's who me and my sister decided to let handle it. He didn't put anybody in charge of the estate. We just got this station escrow or whatever it is.
Well, how does that work? If he doesn't name an executor, then,
Well, did the court appoint your sister as the personal representative of your
I
father?
think so, yeah.
Is it a filed probate?
She's got a lawyer handling it.
Okay. If she's been appointed as a personal representative for the estate owns the land, then she's the one that needs to be notified.
then he's not the guy who's on the hook.
I'm the guy that's gonna clean it up. I throw myself on the mercy of the court. I will clean it up. How about that? It's my junk down there. It's not theirs. I live there.
Well, you can do that, and that'd be a great thing, and it'll all go away,
I've
but,
moved more cars and trucks than he realizes. From back of that thing, I moved a lot more than he thinks.
okay,
And I'm still working on
I can
moving.
believe that. But we don't care, right? If he wants to go ahead and clean it up and the
Well,
violation,
In the meantime, we need to properly make.
Well,
Yeah.
you don't have the proper person
Right.
served for notice.
right, so at this
regardless of-
point, this is not an official action, I
I
can
would
just,
say continue the case
Yeah.
until the next time and get the personal representative properly noticed.
okay. So you guys, the officers need to find out who it is that we need to notice properly, right?
Dan Nelson, 233 Edge Avenue, Valparaiso, Florida.
Okay, well, you share it with them.
Okay.
But look, if you're gonna clean it up, now'd be a great time
All
to
that's
do
gonna
it.
do is make her
Yeah.
call me and give.
Yes, Mr. Rose.
Oh,
Lynn.
this
me in
is Miss
trouble.
Yes,
Chrisman.
Yeah.
Hey, he's honest.
Under the statute, the county has a responsibility to notify whoever it is that's listed as the owner on the property appraiser site. If we have another address, we would certainly notice that person as well. But as it relates to meeting statutory requirements for notice, it is our position that we have met that. If there is additional, somebody else, the pre-R, or somebody else that we could notice, we'd be happy to do that, but I believe we've met our burden.
Well, you're our attorney.
I would err on the side of caution in saying that I would either continue the case because the county was on notice that there was an estate involved.
That's best option, is continue.
When it says the
He's cleaned
estate
it up.
of, obviously, you need to look at who the personal representative is or that there's another person involved, so it's giving them direct notice. I would err on the side of caution and continue the case. The gentleman has said he's going to clean it up, and that gives him his 30 days regardless, so
Right, Okay, so can we just hear a motion to continue the case?
I would suggest it.
You so move?
Or do we need to hear Mr. Marshall first?
No, Mr. Marshall isn't.
You don't need to do.
Want to hear from me?
Okay, wait, we got to vote on it. All those in favor of continuing the case?
Who seconded, who made the motion? Who
I
seconded?
did.
Okay.
He motioned, I second.
Right. Okay. You're officially or unofficially on the hook.
I'm on the hook. Either way,
Okay.
either y'all or her, I got to clean it up. I will
If
handle
you'd
it.
clean it up, you'd do us all a favor.
Please, sir.
All right, great. Okay, let's move
Thank
on.
you.
Appreciate it.
Yep, thank you.
Her name and address or phone number? Do you have one?
Okay, who's going to do number 10, case 20-000-861?
Julie Nelson,
Running out of people.
Yeah. I'll have to do one.
Valparaiso, Florida, whatever the address is. That's my sister, and she's in control of it. All right, thank you. I will be getting it cleaned up while that's going through the mail. Thanks.
Never go to court.
Mr. Rose himself. Whoa.
All right, good afternoon. For the record, my name is Kurt Rose, Walton County Code Compliance Officer. I'm going to be submitting this final report, proof of notification, and PowerPoint presentation as evidence. This is case number 20-000-861, Mark Miller. This address is 3654 State Highway 20 in Freeport. The violation is building permits required. Next slide, please. This parcel is located just east of Black Creek Boulevard, right on Highway 20. One thing to notice on this parcel is in red, it is a small 1-acre cutout of a larger 40-acre parcel.
It's on the south side of 20?
On the south side of 20, correct. Of course, building without permits, you are not allowed to erect, alter, or reconstruct any building or structure without first obtaining a building permit. Next slide. On 2-5, I had my initial inspection, which as you can see from the photo, it shows a shed. There's a partially collapsed shed to the left of it, which is the red, and some other minor junk and debris on the property. I met with the property owner on 3/25. I spoke to the property owner, explained the violation for junk and debris, and that there was, the shed on the property. He stated at the time that he was living in the shed. That was his house. So again, that escalated it more because he did not have a building permit to live in the property at all. And I spoke back and forth with him a few times over the next few months. Ultimately, he ended up moving away and he wanted to sell the property off. So he had a buyer to purchase it, and it went to planning department to determine if it could be purchased and a house be built on it. The new owners would tear it down. However, the designation for the land is general agriculture, and his parents had split off that acre for him years ago, but did it incorrectly. So it is a non-conforming lot, and he will not be allowed to build a house on it. It will either have to be sent back to the original owners, which is his parents, and be reabsorbed into that and split differently. In general agriculture, you are only allowed one house per 40 acres. So they would only, or 1 per 20, I think it is, I'm sorry. So the 1 acre lot would not suffice to meet the density requirement. So
And that roof is actually a building, the silver roof?
the silver roof is the shed, yes. It is approximately 9 by 14, give or take, with a little less, a metal roof on top. After he learned about that, I had not had any more contact with him. On June 9th, I sent the notice of violation. On September 3rd, I posted the property after the notice of hearing, after the notice of hearing was returned unclaimed. I then posted the property on 10/6 with the notice of hearing, as well as the South Walton Annex. This was on 10/20, the current conditions of the property. As you can see, it's still there. I did have another conversation with him between the posting of it and this date, and he let me know that he will not be here. He is actually living now in Cape Coral, and he really didn't have any indication of doing anything with the property. It just is what it is. So I would ask on my recommendation that the vacant parcel located on State Highway 20 East is located within the unincorporated area of Walton County and is subject to 1.1309C. Proper notice of the hearing was given to the respondent. The violation of the Walton County Land Development Code, Section 11309C, does exist. The respondent is to correct the violation within 30 days of the date of this order. The respondent is further ordered to contact Walton County Code Enforcement Department to arrange for a reinspection of the subject property to verify compliance with this order. That if the respondent fails to comply with this above actions or fails to bring the property into compliance with applicable codes, ordinances, and regulations according to this order, the board assess a fine of $100 a day until the property is brought into compliance. Compliance in this would account for one of a couple of things. One, he could ultimately tear the shed down and it's gone. Then there's no violation. It's back to a vacant lot.
Just the shed? That's
Yeah, that's the violation, the structure on the property. The other opportunity would be if his father, which I did speak to his father about it already, would reabsorb that parcel back into his parent parcel. Then it becomes an accessory dwelling on an agricultural property and the shed could stay. Whichever way they want to do it, if he reabsorbs it into his parcel, he'll have to go through a survey company and have it resurveyed and cut back in the same way he had it cut out to begin with. Instead of going through the official channels, it will just be part of the original parent parcel again.
Do the parents live on the other 9 acres or whatever it is?
They don't live on the parcel that I'm aware of. They live somewhere else, but they still own the land around him.
But what I'm asking is if it was reabsorbed or used back in, would it be, you said it would qualify as a secondary structure?
Yeah, there is another structure. There is another structure on the far side of that acreage already.
Okay.
But it would be legal. There's enough.
Then
room
it
for
would be.
both
Then
of
it would ultimately become legal if they reabsorbed it.
Because it's a secondary structure.
It would be it would be an accessory structure on an agricultural parcel.
Okay. Any other questions for Officer Rose?
But the parents still own that other.
They do.
Okay.
They just, at some point in time, got a surveyor to cut out a piece of the land for him and say, and make a deed and say, here it is, this is yours. They would basically have to go back to that surveyor and undo what they did because they didn't do it
So it was assigned
appropriately.
a separate parcel ID by the county?
Not by the county, by a surveyor. And then,
Surveyor doesn't assign
but then it's recorded. Once it gets recorded, then that becomes public record, and then on the property appraiser's website, it shows differently. However, that still doesn't make it a valid lot of record because it did not go through the planning department for proper lot split. Thus, it would not be buildable upon.
So the gentleman that's currently on the property, you say he's moving?
He moved. He's gone. He is
So
now.
he's abandoned the property?
Well, he hasn't abandoned it. He still technically owns it, and as long as he pays his taxes on it, he's still ultimately responsible for it, unless it either gets torn down, eliminating this case, or the parents reabsorb it. One or the other.
Okay, I'm going to accept Officer Rosa's presentation and evidence, testimony into evidence. And anybody got anything to say? I'd suggest they give him a little longer. Guy
I was
lives,
gonna say, how long would it take if they select your second option as far as reabsorbing, refusing land? How
That
long
would
it-
entirely be up to the surveyor that they originally had it done. The average surveyors right now aren't.
No, I'm talking about as far as to work that process through the county, so that it's
To reabsorb it, correct. That would entirely depend on the surveyor that originally did the survey. Most surveyors now are about 3 weeks out, and this isn't a matter of going out and resurveying and reshooting. This is a matter of redrawing the deed to reabsorb that part and make it whole again. So it's not like it's a whole lengthy process that he would have to go through. There would be the cost that would be incurred from that, which I have no idea what that would be for the surveyor to redraw a survey, but that would be the only cost in that regard.
or the guy's got to come up from Cape Coral and,
Or have someone tear that shed down and get rid of it.
how about we gave him 60 days? I don't make motions on the chair.
Anyway,
Yeah.
60's fine.
we're gonna close the public or whatever, close it.
Yeah. Public part. Okay, the public, whoop.
See,
You?
Good job.
You earned your money, yeah.
You're on, but you're on.
Matt Carver from the planning department, if you can hear me.
Yep.
We could accept, just a series of deeds to put this back into the, parent parcel. Without having to go through any other process. And that could probably be accomplished without having to, engage a surveyor. It would just be a matter of, the violator, transferring the property back to the parents, and the parents, issuing a corrective deed that would, redefine the boundary of the property to include this parcel.
So, yeah,
So you're suggesting, Mac, that 30 days is enough?
I think it would be.
Okay. What's the difference? Give them 45 days?
Yeah.
Okay. Let me make the motion.
I move we give him 45 days.
And you'll second it? All those in favor, aye?
Aye.
All right, he's got 45 days to come into
Can we
compliance.
clarify his motion? Are you accepting all the other recommendations
Yes,
with the
I'll amend
change
the
of?
motion to accept all the officer's recommendation and the 45.
Except, Mr. Schneider, did you accept that change to the second? Or you did, okay. Or whoever made the second.
Dave seconded it.
You accept that change, Mr. Lovell?
Yes.
Vote again. No.
Oh, okay, I got you.
You were pretty quick
Yeah.
for me.
Hey, it's getting 5 o'clock, right? We're gonna get.
Second the amendment.
We're almost off.
Yeah, right.
Right, now
Okay.
You can call the vote, Mr. Chair.
I did.
Re-vote on it.
Oh, you want to revote? Okay, everybody in favor of the motion,
Aye.
signify by saying aye.
Aye.
The
Thank you.
motion is approved. Okay, case number 11, 20-005214. Taylor and Almeda Wimberly. Officer Lynch.
96 Gustav. Okay, Board, I'm Michael Lynch, Code Enforcement Officer for Walton County Code Enforcement. This is case 20005214 involving parcel 24 to south 20. Whoa. Okay. 33500-000-0150. Property belonging to Taylor and Almeida Wimberly. This property is at 96 Gustav Drive in Santa Rosa Beach. The land use is neighborhood infill. The codes cited here are 1.1306 permit change and 5.06.02 stormwater management requirements. Next slide. This property is north of Chat Holly. If you go north on North Edens Park, you go up maybe less than a half mile and you make a left onto Cox Road and then an immediate left onto Gustav. And the property is located there in the red. Next slide. As far as the violations, the post-development order and post-permit change, after a final development order has been issued, it shall be unlawful to change, modify, alter, or otherwise deviate from the terms and or conditions of the development order or any permit issued for development without first obtaining approval of a modification of the development order and or permit or field order change for minor changes. Next slide. And under 5.0602, single-family residence stormwater management requirements for improvements in areas having a previously approved stormwater management plan, under A, all improvements shall be constructed in accordance with the approved stormwater plan and certified complete by the property owner. And where this comes into play is this is part of a neighborhood that has a stormwater plan, so if a homeowner is going to make any substantive change that is going to affect the stormwater, then they have to submit a plan to show that it's going to be engineered or it's going to meet with the approved stormwater plan. Elevations, grading, all of that, has an effect on the other neighbors. Next slide. On July 17th of this year, a complaint was received that the property owner has brought in fill dirt and is causing drainage issues. On July 30th, an initial inspection of the area showed a privacy fence which did not allow view of the backyard and sides. Contact was made with the complainant who agreed to allow myself to inspect the property from the backyard. On the very next day, July 31st, an inspection showed that the backyard is generally flat with no taper in the back into a swale. The yard has a more abrupt drop-off into the complainant's property, which would shed water onto the complainant's property. I conferred with professional engineer Andrea Ward, who reviewed the neighborhood stormwater plan. The plan shows that the grading and swales are to convey the water to the west towards a retention basin. And I have a plan of the neighborhood which will show that basin area. On August 4th, I met with the property owner, Ms. Wimberly, at the property and explained the complaint as well as the stormwater plan. I also showed the property owner a video of stormwater gushing from her property onto the complainant's property. I discussed various ways to correct the issue. The property owner advised that she would have her husband contact me. Next slide. On August 6th, I prepared and mailed a notice of violation to the property owner via certified mail. On August 19th, the complainant advised that there has been no progress in fixing the yard. On September 14th, I received a video from the complainant of a rain event on 9/13 of this year showing rain runoff pouring through the privacy fence from her neighbor's property. On 9/17, photos and videos from the complainants and the Bubbles property were added to the case file showing flooding due to Hurricane Sally. A notice of hearing was prepared and sent to the property owner for the October Code Enforcement Board. Next. On September 21st, I received the unsigned returned notice of violation. I requested that also on that same date that professional engineer Andrea Ward inspect the property in respect to the grading. On September 28th, I sent a new notice of hearing with a corrected date to the property owner via certified mail. On September 30th, I made contact with the property owner at her property and advised that the notice of violation that was sent and returned, I actually hand-delivered that returned notice of violation to her. And I advised that the case had been scheduled for the October 21st Code Enforcement Board. I explained that the stormwater issues need to be resolved so that they didn't flood their neighbors, and the property owner advised that they wanted to fix the problem. Next slide. On October 9th, I noted that I had recently spoke to the property owner, Mr. Wimberly, and discussed the stormwater issues. The property owner advised that they had an engineer's letter saying that their property met stormwater requirements. I advised that the changes had been made after that letter was issued that are resulting in flooding issues on their neighbor's property. The property owner advised that if he put the grading back the way it was, there would be more flooding. And that's basically an admission that it was in one condition and they changed it. So he knew that it was different than before. I explained that the water is to flow through swales where it will ultimately end at the retention basin to the southwest of the community. I contacted their engineer, Michelle Baker, and requested any grading inspection or photos from the date she inspected the property. On October 14th, I received a photo from professional engineer Michelle Baker of her inspection of the property on August 15th of 2019 that shows the backyard has a gentle slope into a swale. And then on today's date, an inspection shows no change in condition. This is the grading plan showing the elevations, and I know that the print is way too small to see, but the water for lots 1 through 27 will all flow to the west toward this basin in the southwest portion. That's a large low-lying area, but that's where the water is intended to go. All of the lots and the finished floor elevations, basically the houses are built up to meet the finished floor elevations. The remainder of the lots are supposed to be graded so that the water is directed either to the front of a lot or towards the back to where they will just run in between the lots and houses towards that western retention area. Next slide. This is the engineer's inspection photo on 8/15 of 19 prior to the certificate of occupancy. This is what was required for them to get their certificate. You'll note there that you can see the gentle slope, and there's a swale created there with the property immediately behind. Next slide. So this is what we have today. A retention wall has been built up, and the yard now is flat, which is great for the property owner, but when you look at stormwater and how the water flows, it has a detrimental effect on the other properties. And Kurt, if you could go back to the...
Oh, sorry, that's the back of the house, right?
That's the back.
Where's the retaining wall?
The retaining wall is right there at the very base of the fence. And Kurt, if you could go back to the grading, slide 9, yeah, right there. So what's happening is that the water would normally come in between the houses. Along the front, it would go to the front and then get down between the houses. But when this wall was erected, what it did, there should have been, basically a common swale. But when you put that wall halfway there, the water that's coming down is going to back up and get pushed over. It's now no longer shared. His property is all flat. And so that's creating more water coming into this one lot. And given a lot of those properties in there have privacy fences, and the privacy fences are helping to contribute to the slow flow of the water to the retention basin. But And Kurt, if you could go back to, I think, slide 11. So as you can see, there's a privacy fence both on the north and south sides of this property. Next slide. And this picture is taken from the complainant's property, Miss Lee, and this is the portion of the fence that abuts the subject property. Next slide. The viewable property is directly behind the subject property, so on the other side of that retention wall and that fence is the viewable property.
Not the complainant.
No, Miss Lee, who is beside the subject property. So these are the folks directly behind the brick and house that you see behind there. Yes, that's the subject property. But you can kind of see the retention wall.
Mm-hmm.
That's probably a foot deep. That water at that point.
Is it just a wooden fence, or is the bottom of it masonry?
The bottom of it, it looks like wood construction, whether it's maybe 2x10s or 2x12s, and then it's probably backfilled. I don't know if there's concrete or anything there.
But it's impervious, whatever it is.
Well, it's backing up water, and any water that does come down is just going to shoot down out of the fence. And at looking, I know you can't tell from the photos, but in the subject's property, towards the middle of their backyard, you can see a gentle slope to the sides. So they're really not going to retain any water in the back. It is going to shed to the sides.
Right.
But unfortunately, that's where their neighbors are.
Right.
Next slide. And during that same event, rain event, where the previous slides were taken, this is the subject property. And you'll note that there's really not backed up water like their neighbors are experiencing. The next slide, if you will. And Kurt, if you can, click on the picture, and I'm hoping that this video. So the water you see coming through the privacy fence is onto Miss Lee's property, and this shouldn't happen. When you have a swale, you will have shared water that is then going to be conveyed to another, outfall, or where the water is going to be directed towards the retention area. But there's not a shared swale here. So.
Well, they filled the swale in.
Right, and it's instead of a nice slope coming down and having a shared swale with the next property, it comes at a very abrupt, and it sheds the water right at the property line. So the complainant's property continually gets flooding.
The complainant is the house directly behind that house?
No, to the side.
To the side?
Yes, this is
To
taken.
the low side?
Yes. Now,
No, to the high side.
The finished floor elevations for the houses are pretty much the same, but it's the grading.
Right, but the swale's running from north to south, right?
Yes, the swale should run north to south, and then go to the west. The
Right.
water that goes from the
The
swales.
swales between the houses run north-south.
Right.
That channels
Right,
the
that's
water
the
down to the main
intended.
swale that runs east
So
and
that
west.
between each house, the houses are graded up, but then, the water is supposed to convey to the front.
Right.
And move then to the west or to the back.
Yeah.
And then move to the west.
Gotcha.
And again, there are several homes with privacy fences that kind of obstruct that flow and don't allow it to go easily. But with this elevation, it's causing some issues.
Pounding water.
Yeah.
Is there an HOA there?
There is, and I've offered to come in and speak to the residents at their next meeting and explain that subtle little changes that they do to make their lawns a little bit more attractive or useful are going to have typically a detrimental effect to their neighbors, including privacy fences and any other structures that's going to impede the flow. This is the notice of violation sent on August 6th. The notice of hearings with the signed return receipt. And then this morning, basically, I just walked down the property line, and there's not been any change. One thing you will note that in the corner, and in speaking with the property owners, they wanted like a little vegetative area, and so they put some some landscaping block there in that back corner. Well, unfortunately, what that was also doing is taking some of the water coming down, and it was directing that right at the complainant's property, which is the property to the left. So, and you've got the downspout to the gutter pointing again down there. And there's a lot of things that we can do to mitigate that. You know, we can use river rock and diffuse the water, slow its velocity down. But in this case, as you can see from the very first photo, the grading has been changed. And so what we're asking is that the property owner either go back to the original grading that was approved, or if they want to have it re-engineered, it could be French drains, it could be any other water mitigation, but the water needs to go where it's intended to go. Next slide. For recommendations, I'd ask that you please find that 96 Gustav Drive in Santa Rosa Beach, Florida, parcel 242 South 2033500 0000150 is located within the unincorporated area of Walton County and is subject to Chapter 7 of the Walton County Land Development Code. Please find that violations of the Walton County Land Development Code 1.1306 and 5.06.02 do exist on the property. Please find that the proper notice of the hearing was given to the respondent. The respondent is to correct the violation within 60 days of the date of this order, and that the respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for a reinspection of the subject property to verify compliance with this order. That if the respondent fails to comply with the above actions or fails to bring the property into compliance with the applicable codes, ordinances, and regulations according to this order, the board assesses a fine of $200 a day until the property is brought into compliance. At this time, I'd ask you to accept my testimony and presentation into the record.
I will accept it into the record.
And any further questions? And the property owner is here. Mr. Wimberly is here, so I'm sure he'd like to.
Okay, then we'd like to hear from Mr. Wimberly.
Quick question.
Yes, sir.
Do you have to have a permit to move dirt and build that fence?
You don't have to have a permit to put in a fence on your property line, but if you're going to alter the stormwater plan, then that needs to be engineered because there's more people at stake. A fence is a fence, but if you're going to change the grade, which is what happened here, then that requires a permit or an engineer.
So a permit was never granted?
Yes, sir.
So that's the whole point. I mean, it's nice to understand what the water's doing now, but the long and the short of it, they altered the approved grading and drainage plan.
Okay.
Right, there's a neighborhood stormwater plan in effect.
Okay.
It's illegal, so.
Okay.
Anything else? Mr. Wimberly?
Chairman, Board, I was sworn in earlier, but my name's Taylor Wimberly. Okay, so just one thing that I do want to clarify before we start is I came into the property on September 1st, 2019. I did not hire a contractor to backfill anything into that property. I did not add dirt to my property or build that wall there. That was done before I moved into the property. The contractor did that. Per my contractor, who I purchased the house from, that was good to go and inspected. So I purchased the home in that condition.
He did the work specifically for you? I mean,
Prior to me owning the home.
You said when I owned the home, I want it to look like this, and he did that. Is that right?
That's incorrect.
Okay, it was that way and you bought it that way?
Correct.
Okay.
So I mean, obviously we were under contract, et cetera. They were still building the house, but I did not hire my contractor to backfill that and build the fence. Obviously the privacy fence was part of our closing agreement that we'd have a privacy fence, but backfilling it was not part of our agreement. That's just what the contractor had done when I inherited the property or purchased the property.
Yeah.
Correct. So the only thing that I was admitting to Mr. Lynch was adding that that bed on the northwest corner of the property. That's what all the only revisions that I made. I just wanted to clarify that for the record, that I did not pay anybody to backfill my property.
Okay.
Okay, so really, ultimately, you know, I didn't understand the full extent of the case. I didn't realize that we were being charged for
this extent of a violation. I did not know that prior to this. I simply thought that us building a bed in the corner of our property was the reason for all of this. A few things I just do want to point out as we go in on slide 12. Oh, the text box for the Zoom call is in the way. You can clearly see in this photo that my property is completely backed up as well. And then if you go to slide 14, I just want to say this is a very deceptive photo because there's probably 14 feet between that fence and that grass line if you follow it all the way to the edge of my fence. So had there been a photo taken on the other side of the fence, you would see that my yard looked just like my neighbor's, completely backed up and flooded in that swell. So this distance between the top of this fence and that grass, if we're looking at it from this direction towards the fence line, would be about 12 to 14 feet.
I got you.
So both of those photos are radically deceptive of the reality, and I wanted to utilize because I don't have any of my own photos to present as evidence, but in photo 12, you can simply see, if you go back to slide 12, that even in the photo that they provide, you can clearly see that even though I've already built that bed, that water is backed up on both sides of the fence line. Furthermore, my neighbor's property fence line is below, her property falls below the fence line where mine comes to it. So no matter what, water is going to flow into her backyard because her property's lower on the fence line side. So those are just a few things that I wanted to point out with just the nature of the corner of the flooding from the person who has actually filed the complaint. Although it would appear that Mr. Bubbles' backyard, who's more egregiously, impacted by this, which I did not know the extent, has never filed a complaint nor complained to me, nor would, from my understanding, considering this has been going on for a long time and we talk all the time, and he's never once filed a complaint. What is nice, I think he lives in Florida and understands that we all deal with groundwater. I mean, every time that it rains inside of this neighborhood, water just is absolutely everywhere. And then over the course of a few days, it goes away. So this particular neighbor is just apparently trying to impact that change. So that's really all I have. I don't know what direction to take to solve this issue. Again, when I purchased the property, that's the way the backyard was. If I need to contact my contractor and have him come and knock all that out and put a new fence in, it looks like that's what I'm going to have to start doing, but that was how I purchased the property. And according to him, that passed inspection. I know the photo from 8/15 showed a different story, and that all did take place between 8/15 and me closing. That is true, but I guess there was a lot of different conversations between him, Mr. Bubble, because I talked to him on the phone today, as well as code enforcement who came out and inspected the property post 8/15, according to my contractor.
So when did you purchase the property?
I closed on 9/1
of
2019.
19.
Correct.
So if I thought I had understood, Officer Lynch said that he acknowledged bringing in fill at some point.
Yeah, I misunderstood. I acknowledged building the bed. I did not bring any
I
fill
was
dirt.
addressing that question to Officer Lynch. I wanted him to clarify what.
Yes, the communication with Mr. Wimberly is if I put the grading back the way that it was, then there's going to be even more water. And along the side, and I know I'm not doing a very good representation, but where Miss Lee's property comes down and it does flatten out and have a pronounced what would be a swale, Mr. Wimberly's property comes down and then is more abrupt. So while he may still experience water backup, but it's not to the extent he is shedding water, and you could see clearly by that video that shouldn't happen. You shouldn't have water gushing through the privacy fence like that.
The water should be running parallel to the fence, not through
Yes.
the fence.
Yes, it should be shared, not being pushed onto another property. I believe Director Carpenter.
When you're done, Director Carpenter will like to talk.
Okay. Do you mind turning that mic to the computer in front of you? And we'll hear what he says. Matt, go ahead.
Thank you, Mr. Chairman. I think the specific violation before you is a post-permit change that altered the stormwater plan that was approved for this particular development. And I think evidence has been shown that the final inspection for this development was in compliance with that stormwater plan. It's pretty obvious from the pictures that there has been some alteration. Now, the current property owner indicates that he did not create this violation, and I would not disagree with that, except that the Land Development Code doesn't make a distinction between who created it and who owns the property. If you buy a property that is presently in violation, whether or not that violation has actually been filed or not by code enforcement, you bought the violation and you're responsible for correcting it. And I would suggest that the correction, at least the instant case of correction here, would be to place the property back into compliance with the approved stormwater plan that clearly shows the swale in the backyard, and to remove the retaining wall that's been created underneath the privacy fence that restricts water flow underneath that fence within the shared swale that's part of the approved stormwater plan. And that may not correct all of this flooding, and there may be other violations there, but based on the evidence that I've seen, this is a clear violation, a post-permit change that violates the provisions of the approved stormwater plan. Happy to answer any other questions.
It's Dave Lovell. Is engineer Ms. Ward, I believe her last name, correct? She's works for the county, is that correct? And so she.
Yes, sir. She's one of our planning project engineers, well versed in stormwater.
So, and I think I understood Officer Lynch to state that she did verify that the in situ situation, or the in situ conditions were different from the approved grading and drainage plan, correct? So
yes,
she did
sir.
verify that. All right.
Any other questions for Mr. Carpenter? One more time, there's a privacy fence, it's boards like this, okay, that water can flow through. But beneath it, you talk about a retention wall. What does that wall consist of? Do you know?
Yeah, it's dirt from what I can tell. Dirt, and they built up a fence, they backfilled it with dirt. And they've done it, several other lots have done it inside of the neighborhood.
Yeah, but the fence sheds water, so it would shed dirt too. As the water flows through it, the dirt would wash with it. Yeah.
So commonly, when you build a retention wall in a backyard to hold it up, you're going to build it out of 2x10s. You'd put a permeable sock type or mesh product like silt fencing and such along that wood and backfill it.
That does exist.
There is a filter
And
fabric.
it'll be a filter fabric of some kind that would allow water to percolate through, but not allow sand or siltation to blow out the structure.
So it really is a retention wall, not a privacy fence.
Based on on the photos, I would say, yeah, it's a retention wall at that point.
I'm a site contractor, I do it for a living, and I'm just trying to figure out exactly where we're standing here, okay?
He's
Site
got
was
a
altered.
fence that's got filter fabric up to a certain level.
Yeah.
And they somebody, as a contractor, whoever.
Somebody backfilled up to it.
Backfilled up to that level.
Oh, okay.
And then the water
I
spills
I
over
got
his
it,
block.
okay. Yeah.
If you look at this photo on the left, where the gentleman is kneeling down,
Yeah.
you can see where the 4x4 kind of for the fence post makes a cut, and it drops down to what looks like 2x10s or something that are flat against it.
I got it.
And the fence panels sit above that. So
Okay.
that bottom portion is actually what would be the retaining wall, and then the top portion is
So
the fence.
to remedy the situation, you need to remove that
All gotta go.
2x and the silt fence, and then grade gradually back down
Grade the back.
to the
That's the way
swale.
it was.
Yeah.
So this is, I'm not the only yard they've done this in. There's
No,
more-
I know, but this happens all the time. You're the guy standing in front of us.
No. I'm not the only yard on the row of houses. There's more lots that have the same exact structure.
I get you, but
Okay.
again, we only hear one case at a time, so we got to cure one case at a time. You can bring a complaint if you wanted to against the neighbors, but we're just going to talk to you, and I know there could be violations in every other yard, but it doesn't help you any.
Yeah, okay.
Okay.
understand.
But look, the remedy is not that it's not that expensive or that difficult. You could do it.
I
And if I could,
don't know how I could do that without a Bobcat, but yeah, I guess I could.
Well, you
There's
just
no
need-
access.
You need to show, yeah, okay.
Yeah.
Yeah, Mr. Lynch.
and one thing, Mr. Wimberly, I might offer is that if this was not to your direction, if this was the contractor that did this, I might address this with the contractor.
Oh, no, my contractor's gonna fix it.
Yeah, that
I
would
did
be-
not
that'd
do
be my
this.
first.
Because I didn't want you to think that we're necessarily coming at you. We just
No,
want to correct
And
it.
again, the only reason I thought this was, I did not know this was about this. I thought this was about the bed that we built on the northwest corner of the property, considering that she's the one filing the complaint.
No, but you understand why she's,
Oh, no, I'll bring it back to compliance, and she's still
Yeah.
gonna have water on her property. It won't change at all, so.
yeah, but then she'll not have that
Correct.
ability to complain to you about
Absolutely.
it. Yeah.
All
Okay.
right.
All right,
All right.
Thank you, gentlemen.
Yep.
thank you.
Okay, so we'll close the public part of the hearing, and we just need to make a motion, right, that this thing gets remedied.
I'd be giving more time.
How long did he have? Wait, you gave him 30 days?
I recommended 60 days because I knew that there could either be engineering involved or contracting a developer or contractor to come in and actually do the grading.
60 days are $200 a day. And again, there's no fine as long as the COVID pandemic emergency exists.
Unless we change that next one.
Yeah, unless somebody next week votes it out, which seems unlikely.
From today's date.
Okay.
I call you for.
Wait, we haven't quite done it yet.
Oh.
We're going to now vote, and you'll hear it officially.
Okay, I so move we accept Officer Lynch.
Mr. Harrison, the motion has been made to accept the officer's recommendation.
I second.
60 days or $200 a day.
I'll second it.
And you made the motion, you seconded the motion, I'll call the question. All those in favor, aye.
Aye.
Now it is official. Okay.
Get it done before, call us,
Few days.
and we'll come out and we'll check it, and as long as it's done, it's a done deal.
Oh, no, hey, the fun keeps,
Last one.
The original grade.
the
Yeah.
hits keep rolling. Okay,
To have
let's
the
do it.
grading
Number
that was-
12, the final case. Case number 20-003798. The Audrey Chapman Testamentary Trust. And who gets the privilege of doing the last one? Mr. Cross, looks like your number. No?
Mr. Butler.
I know we look alike, but he was in the
Oh,
Coast Guard and I was in the Navy. Once again, this is Lawrence, Walton County Code Enforcement Officer. I'll be presenting case number 20-003798. The parcel ID is 14-3 South-25040-006-00110. The property owner is RBC Chapman Testamentary Trust, and I believe Valerie Chapman is on Zoom for the meeting. She is
okay.
the person I've been working with, the
Patient
owner.
lady, yeah.
The land use is residential preservation. The violation is 7.02.03A, dilapidated structures / prohibited conditions. Summary up front, our officer received a complaint of, this is wrong. I got a low battery up here, I can't. You can skip this slide, please. Okay, so the location is 51 Elm Street, which is if you go north on South San Juan Avenue off of 30A, if you're familiar with that area, that's where we're at.
Yep.
You go up and you take a right on Elm Street and you go down, it's that last.
Got it.
Okay, the code violation was 7.02.03 dilapidated structures, Section A prohibited conditions. I'll put the entire code in here if you would want to read that. Basically, it's a dilapidated structures constitute a public nuisance and are prohibited. This is a more recent case, so I try to will it down as small as I can, especially since it showed up number 12 on the agenda. So June 3rd, our initial complaint was received. June 23rd, I conducted an inspection. July the 1st, I sent a notice of violation, which was returned. September, I sent a second notice of violation and a notice of hearing. And September 29th, I posted the notice of violation and notice of hearing to the property. And then 10/16, I had a discussion with the owner, Valerie Chapman, and explained the violation and the code board procedures. And then we'll just go through the inspection photos. So this is a small shed on the property that's fallen down. The front door is open and falling down. The mobile home, you can't see it from the picture, but the small window at the top on the left side there is busted out. And the front deck is in bad shape. Next slide, please. You can see from this side that some of the skirting is missing. Some of the windows have, looks like what, maybe aluminum foil or something on the inside. Next side, the back door is standing wide open, and the window at the top of the back door is actually busted out as well. And that deck is in pretty bad shape as well. The next slide, this is a notice of violation that was returned. And then the next slide is the notice of violation and the notice of hearing. Those were sent on September the 29th. And then the tracking number for the notice of hearing. And then the delivery confirmation for the notice of hearing. And then this is when I posted the notice of violation and notice of hearing. Up close photo of those two documents. And then I just had some random additional photos I put in just so you could get an idea of what the property looks like. So you get the back deck. If you look across the property, you can see the little shed on the other side. It's in pretty bad shape. Then a close-up picture of the shed with the door falling off of it. And then a picture from the front with showing further back, showing the overall property. And then this is this morning. See the shed, and it's nothing has changed. A little bit of overgrowth on the property as well. I would note that some of the concerns from the complainant were the property is in bad shape and that kids are playing and going inside. And I did, on one of my inspections, find a young male walking into the shed looking around. So I asked him to leave the property.
Your meth house.
So for my recommendations, please find that 51 Elm Street, Santa Rosa Beach, Florida is located within unincorporated areas of Walton County and is subject to Chapter 7 of the Walton County Land Development Code. Please find that a violation of Section 7.02.3A of the Walton County Land Development Code does exist on the property. Please find that proper notice of hearing was given to the respondent. The respondent is to correct the violation within 30 days of the date of this order, and that the respondent is further ordered to contact Walton County Code Enforcement Department to arrange for a reinspection of the subject property to verify compliance with this order. That if the respondent fails to comply with the above actions or fails to bring in the property into compliance with the applicable codes, ordinances, and regulations according to this order, the board assess a fine of $150 a day per violation until the property is brought into compliance. At this point, I would ask to accept my presentation and testimony into evidence, and I would answer any questions that you may have.
I will accept it into evidence. Any questions?
How many violations are there?
Just the dilapidated structure. There's two structures, but my intention was $150 a day if it's not.
Okay, that's what I just wanted.
You said 30 days or $150?
Yes, sir, and that timeframe may be, I don't know if it's your discussion on that one, but with everything going on, it may take a while.
We saw some movement
She
towards.
does live in Texas, so finding somebody local to take care of stuff may be a challenge.
Mr. Rose knows someone. To take down the tree.
Right, and she is on, I believe she is on Zoom.
Okay. And do you want to speak to us? Ms. Chapman, can you hear me? If we can get her. Yeah. Great.
On video that we can see who she is.
I don't think so. We haven't been able to see Mag. Can you hear me, Ms. Chapman? Whoa, we got a good echo going. It might be at her end. Okay, let's try. I can hear you. Were you sworn in the beginning of the meeting?
Hello?
Yes. Can you hear me? Hello?
Hello?
Hello? Can you hear?
Okay, sorry. I don't know what was going on.
Oh, good. Can you hear me now?
Yes, sir. I don't know what happened, but I can hear you now. Can you
Okay, great.
It seems
We're-
like you guys can hear me as well.
Yep, we can. Were you sworn in at the beginning of this meeting?
I did stand and swear in, yes, sir.
Okay, great. Then you can address us at this point. Tell us your side of this, okay?
Yes, sir. So the property was my father's property. He did pass away a few years ago, and so I am the executor of his estate, so it has fallen into my hands to upkeep at this point. I do live in Texas, so I don't have easy access to the property. I have gone a handful of times through the years since my father's passed away just to check on it. It at those points had never been this bad. I guess in the last couple of years, it looks like people are probably breaking into it at this point. So I know I got a notice for the yard beginning of this year, and I did try to get that corrected as quickly as possible. So I am working on it. I didn't get the first notice. I called when I got the second notice. I did call Mr. Butler and explain my situation. I am working on it as quickly as I can. I understand it's an eyesore. As a homeowner, I understand the people's frustration. I'm frustrated with it. To be quite frank, I have prayed for every hurricane to pick it up and take it into the Gulf. But I have contacted the local fire department to see if maybe they could utilize it for some sort of training purposes. I've also reached out to the Walton County Building Department and asked them to send me a list of registered contractors. And then I've had a couple of people reach out to me because they've seen the signs interested in buying it. And one gentleman, when I told him I really did not want to sell if I didn't have to, he said he had a friend that does demo work and is actually supposed to go look at it tomorrow to give me some kind of estimate as to what he would charge. That's been my holdup from getting the trailer and stuff taken off prior to now, is it's just not it's not a cheap process. And I just don't have a lot of extra funds. I too work for a municipality, and we all know they don't exactly make big bucks. So, but I am actively working on it. I wanted to make sure Mr. Butler knew that I wasn't ignoring the problem or blowing it off in any way. I just had not gotten the first notice and didn't realize it had gotten to this point. So I just ask that you guys be patient with me. It is difficult working, on it from 4 or 5 states away. I don't have the ability to easily contact people there. I don't know who the trustworthy contractors are, but I am really trying to research that and find some type of solution that's going to benefit everyone.
Okay. Well, thank you for your input, and we'll take it under consideration.
Except for testimony.
Yeah, I'll accept that into evidence, what you've said.
Thank you.
Okay, then I'm going to close the public part of the hearing. Okay, seems like a nice lady, well-intended. Give her a little extra time.
So, yeah, Ms. Chapman? Ms. Chapman? Oh, you did, never mind.
Yes, sir.
Yeah, I was just gonna say, if I think the recommendation, included a 30-day compliance period. So if we extended that to say 45 days, would that be adequate, you think?
I hope so. I mean, I'm not blowing it off. I am working on it as quickly as I can. Obviously, I don't know how long, because even once I find somebody to do it, I don't know what their timeline of being able to complete it would be, if that makes sense. But I can always show you proof where I'm actively doing something. If it gets to the 45-day mark and it's not completed, I can at least show you where we are at it, that it has been actively worked on, if that makes sense.
Yes, very much so.
Yes.
Thank you.
I would just like to add that there was a previous case on this property for the overgrowth,
Uh-huh,
and she did get that taken care of earlier in the year.
okay, great.
So she is not one of these people that's just
Telling us stories.
ignoring the problem. She is actually.
I'll do a motion.
Is there any assistance that we can give her to get a contractor or something? I mean, is there anything
I don't think
that,
we're allowed to do that because it would be like showing favoritism or
Yeah.
promoting one contractor over another, and I don't.
is there a
I know
department that we can
I know in
refer
our
to?
municipality, we're not allowed to give recommendations, but we are allowed to give out a list of registered contractors.
Call
So
Porter.
I did call and ask for
Get
that. I've not
Porter.
received it yet.
Okay.
If she's so far away, I just think if we could offer like that was just recommended.
County's not allowed to.
And I did post on the 38 pages, Facebook pages as well. Nobody ever answered anything on there either. So it's just frustrating, because I really am trying
Called
and
three
I can't seem to get anywhere.
Turn call.
Well, remember too, keep in mind, she could sell the property. She's had offers to purchase it. She's electing not to. So, I think if we give her the 60 days,
Give her 60 days.
days, and otherwise, if you're ready for a motion on.
Okay, you make it.
I'll turn that into a motion and find in favor of accepting Officer Butler's findings and recommendations, with the exception of extending the compliance period to 60 days.
And that fine of $150 a day if she doesn't come into compliance once the COVID pandemic emergency has been declared over.
Right.
Okay.
That's part of his recommendation.
Second somewhere? All those in favor, aye?
Aye.
It passes. And hearing that, I would.
I got one, just one quick thing. I won't drag it out, but back on the time discussion, obviously Victor was pretty indignant about it,
Yeah.
I personally don't have a problem with the time change, but I assumed that it was just maybe a one-time thing where we needed to change the meeting for a day, because I know it was for September, it was changed to Wednesday at 5, correct? Until we canceled it?
Yeah, well, when we initially had the hurricane and we had to cancel the one, we tried to
Right, but it was at
squeeze
5
it in.
o'clock. It was at 5 o'clock. not
Yeah,
2.
we were trying to squeeze it in somewhere, but the problem with changing that at such a rapid and close date was that we ran into issues with notices. Because even though we
Well,
called
yeah, I understand that. That's not my point. My point is, so this is a permanent change that somebody made
The Board of
decision
County,
on without
Who
coming
made
to us.
the
this was the BCC.
Okay.
This was, I mean, I found out about it, we'll put it that way.
That's the current makeup of the BCC, not resulting from the recent election, right? This is the old board, the board we're used to.
The current board, yes. So the third Wednesday at 2 PM was determined to be the new meeting time.
Well,
That makes it
I
difficult
think
for
it's
the
a
people
little-
too.
as the chairman of the board, I'd like to tell them that I would have appreciated some consideration before they arbitrarily changed the time.
People out here working, they gotta get the,
Oh, absolutely.
Okay?
that was
I mean,
wrong.
that's been
That was a stupid
case
decision.
every other.
I
last 20
understand
years
that
I've been on this board.
from an economic standpoint, it may make sense, but
I think that's what they were, because with our budget, between professional services and overtime. The only overtime that our officers get, we're not like the TDC, the only overtime our officers get is for code board. And
Couldn't we change the hours of the day on that,
That's what we do.
on those days? When there's a board meeting and instead of reporting at 8 in the morning, report at noon?
I would have to run that by our new director.
Okay.
And see, because if a majority of our board is saying this is not acceptable, either in principle or in practice, because of your jobs, your other responsibilities, I'll certainly take that to the director and let them know.
It makes me, I've been on this thing forever, okay? But it makes me inclined to think that perhaps retirement time is approaching. This earlier Wednesday at 2 is difficult.
Then you'd have plenty of time.
Yeah, right.
Kidding.
Okay, anyway, I just wanted to know that we're not happy about the way it came about.
Yeah, I mean, we would appreciate it at least some.
Yeah, at
Who,
least.
who, can I ask who
Who
was
made the
there a
motion?
request
Commissioner was it?
made of the board of commissioners, or did they just
I have no
bring
idea.
it?
It just came down from us
From on high.
Yes.
I think it sounds like it was. I guess it's to reduce or eliminate.
And there
overtime.
wasn't a discussion. It was, our date and time is changing.
Are they aware we're professionals with volunteering our time? Hold state licenses?
You're preaching to the choir.
None of them do, by the way.
Right.
Maybe they're-
We all have a role, right? He's the engineer, I'm the subcontractor, somebody's the real estate people, right? So, we're all theoretically working people.
We're expensive. Yeah.
And by statute, we have to have that multidisciplinary approach because you all
right.
bring something to the table that, you can have, shed light on, things and.
Maybe you should get the county manager to find out how this came about and contact each of us and find out. And
Yeah, or at
have
least
the
at the next,
courtesy to poll us
at
first.
the next board, if they could have someone explain to us why it happened and why it's justified, it would certainly go some ways to appeasing us.
Well, our director is out this week, I think on personal time or vacation, so that's why he wasn't here today. But for the next meeting, I will absolutely
Encourage.
suggest his, his presence here, and he might be able to offer explanations that I have no explanation for.
No, not yet. Okay, I'll entertain a motion to adjourn. We are adjourned.
Y'all have a happy Halloween?
Hey,
Oh, yeah.
Lots of candy?
Johnny just came up positive in St. Pete.
David, Davis had it a few months ago.
I know, when you said Andrew Priest, I went, not that Andrew, are you kidding me?
That's my first name I thought of too.
Oh.
But Andrew's supposed to, yeah.